Take it to trial. Take it to trial. Welcome in, grab a seat, hit the like and subscribe. The Sweet Peas on the mic with that spicy little vibe. Got the courtroom streaming in the chat, going wild. We're debating heavy topics, but still laughing like a child. From objections to confessions to the judge's side eye. If it's justice and it's messy, we gon' talk about why. Every day's a new case, every moment's a ride. And when Sweet Peas in the building, we be learning with pride. Minds on deck, keep the room running smooth. Film freak therapist, you know, keeping everyone in the groove. Right with the facts, pretty brown girl with the sass. Moreldia and Fowler keep the peace in the chat. But Jason walks in and the ladies collapse. Chocolate. Take it to trial, where the truth gets loud and the laughs run wild. Sweet Peas got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial. Morning shows are sharp, afternoon is on fire. And we catch every moment that the court might inspire. From witnesses whispering, the lawyers trying to hard. You know Sweet Pea breaks it down like a legal tarot card. Chats cracking jokes, dropping theories on the fly. We're serious when it counts, but we still testify. Minds hold it down when the trolls try to play. If you write a line, court adjourned for the day. But when Jason logs in with that deep hello, the ladies in the chat, man, they all fall down. Take it, 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 take it to trial, where the truth gets loud and the laughs run wild. Sweet Peas got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial. When the sun goes down and the cases get deep, after dark gets spicy, no secrets to keep. Taboo topics, big laugh, slap, happy crew. Sweet Pea says behave, but we never really do. It's opinions, confessions, stories untold, but we handle it with heart like the chat made of gold. Hey! Take it to trial, from day to night and every wild mile. Sweet Peas nearly strong with her trademark style, and the fam in the chat always makes it worthwhile. Turn it up, show some love, hit the like on sight. Take it to trial. Yeah, we live tonight. Take it to trial. Yeah, we live tonight. Take it to trial.
Okay. It's probably gonna do it again. Oh no, I didn't do it on replay. Okay, so today the judge is going to be hearing the arguments in regards to splitting these cases. Now we know we got our last 4 defendants that need to be called up to the bench. We have Sean Gaffright, we have Rashad Murphy, we have Davion Murphy, and we also have Isaiah Chance, Alicia Andrews' baby daddy. As I told y'all earlier, we are going to go and watch. We are going to watch the actual hearing. And then once the hearing is over, I am going to go into Alicia Andrews' new update. She did have a hearing earlier. I'm hoping the documents will be in the file once we get done. That way I can explain it to you. So that's why I'm not going to do it at the top of our stream. I'll do it at the bottom of our stream. But without further ado and hesitation, shout out to Corey and her trial that we can actually go in here and kind of take care of this, because I was trying to figure out when I was going to do it, and I really didn't want to wait till Saturday. So let's see what the judge is going to be deciding in regards to, are we splitting these cases, or what are we doing here? Like, what are we doing? And why are we splitting them? Why do they want them split? I have so many questions, and I'm hoping they got some answers for me, because I don't even understand why we doing what we doing. Do it. All right, guys, let's go in here. I got to switch the names. I got them backwards. You have to switch the names of Davion and Rashad. I got them switched around on my thing. I keep getting them mixed up. Okay, she said I got to switch them around. Wait a minute. Let me go look at it, Lynn, so I can make sure I can write it down. Okay. So, okay. They both look the same. Just they want to say two ones with the cray hair. Okay, so Rashad is the one on the left. Okay. Okay, Rashad. Girl, I keep getting them mixed up. I don't even know what to do. I want to say thing 1 and thing 2. Can we call them thing 1 and thing 2? Then that way I don't have to be wrong. Maybe I'll just change it to thing 1 and thing 2 because I can't keep up with them. They both look the same to me. They cousins, so they got features alike, and they got this whole messy hair that's so scary. Okay, Davion wrote the note. Okay, that helps me out. Go ahead and get it, Glenn. I'm gonna call them thing 1 and thing 2 because that's what they look like. A scary 1 and scary 2. At least Isaiah Chance, he almost looked like a little boy. He looked like he got the little beady bees up there at the top of his head. You know how the little boys when they ain't comb their hair in a while, and they got the little buckshots, the little beady beads. He looked like he got the little beady bees. And then we got Sean Gaffright. I can tell him from everybody else because he looking like he is the the boy that the light-skinned boy. That's how I can tell him. So I can tell them two apart. But I tell you, scary 1 and scary 2, I don't know what to do with them. Thing 1 and thing 2, we're gonna call them thing 1 and thing 2. Okay, thing 1 and thing 2. So thing 1 is gonna be our letter guy. We'll make him thing 1. That's Davion, because we know him by the letter, because he was sending out SOS signals. And Rashad will make him thing 2. Because I'm like, I can't keep up with these two. They look just the same. They look just as nutty buddy as nutty. That hair has convicted them in my eyes. That's what I can tell you. Their hair has put them on trial. Okay. Let's go ahead and get in this courtroom and see what this judge is going to be doing. No, she said it's Davion that had to know. Thing 1 had to know. I probably got all my thumbnails messed up because I'm telling you, I've been trying to figure out a distinction between thing 1 and thing 2, and I couldn't figure it out. I'm gonna have to go back and make sure all my thumbnails together because I may have to be switching them up. But here we go. Let's go ahead and get into court today. This feed is probably about maybe a little bit over 3 hours long, so we won't be here that long. You say Rashad is the depressed one. Oh, that's a good way. The one that looks stoned. He look like he's stoned out. I don't know why he's depressed now. He over there looking like he's stoned all the way out. He look like he's stoned. All right, let's go in here.
Buddy. Good morning. All right, good morning. All 4 of the defendants are present. Their counsel are all present. State's present. Good morning. Good morning. All right, let me get set up here. Okay, so some housekeeping matters first. Let's see. All right. I know that when we were here on Tuesday that Mr. Gathright had some motions that I think I ruled on, but I couldn't locate the physical copies. So I just wanted to make sure that we're all on the same page regarding the fact that all of the motions have been ruled upon. All right.
Yeah, sure. The only one, and I saw it was on the list, it was sent out last night. The only one that hasn't been is really the firearm motion.
Okay.
The state and I discussed, I mean, I think it might make the most sense to kind of proffer it and address it with the expert.
Okay. Well, I do have that one. So there were 3 motions that I located in my stack of pleadings. And I just wanted to make sure that I had addressed all of them really for the clerk as well as for Mr. Gathright. And I believe that they were, the first one was a motion to declare section 921.1416I unconstitutional as written and as applied. And I think that was the CCP aggravator, which I denied. So that has been denied. Do you need it?
I'll just check it just to make sure I got it.
Okay.
I think I got it.
Okay, I think you did too, but just to make sure. And then the other one, the second one was motion to declare section 921.1416B Florida statutes unconstitutional as written and as applied. And that's the prior capital or violent felony, which would be contemporaneous in this case. And I believe I ruled that it was denied. Just want to make sure. And then finally was a motion in limine as regards to general procedures. And there were paragraphs. I think A was granted, B was granted. And C was granted as to the names, but denied as to questionnaires. So granted in part, denied in part. Individualized and sequestered voir dire was denied, and contemporaneous objections, paragraph E, was granted. All right. So Madam Clerk, that was granted in part, denied in part, as articulated. And okay, so I think those are the 3 motions that I located my copies of. Also, I had taken under advisement Rashad Murphy's motion to allow testimony of the impact of defendants' execution on family members. And specifically, Mr. Rashad Murphy had cited to Lugo versus State at 845 Southern 2nd 74. I did take a look at that opinion. And in that case, the defendant had one of his proffered mitigating circumstances was that his execution will have a tremendous negative impact upon the lives of his elderly mother, siblings, and 6 children. In this case, Mr. Lugo contended that his sister passed away. He adopted her 4 children and assisted in raising them. So in that case, what the real issue was what the issue on appeal was, Mr. Lugo he argued that mitigating circumstance outweighed the aggravating circumstances, and the court said no, and that was affirmed. But it does appear that this mitigating circumstance was offered, which was his execution will have a tremendous negative impact upon the lives of his elderly mother and siblings. So for that reason, as the motion is drafted, I'll grant the motion. All right.
I will
So-
pass it on to Mr. Hernandez, Judge.
Yeah, just let him know. And really, and this applies to Mr. Rashad Murphy and all of the defendants in this case, obviously, if we get to a penalty phase, you and your counsel can and should tell the jury every great thing about you, every redeeming characteristic about the totality of your life. Okay? So, all right, very good. All right, so let's move on to which would be Mr. Gathwright's defendant's motion in limine to preclude the state from presenting firearms identification evidence, and then the state filed a motion to strike Daubert hearing request in defendant's motion. So how are you all suggesting that we handle this?
My position in the motion, and I know the state's early excuses, is that this firearms identification evidence is not product of reliable principles and methods and should not be.
I'm sorry, excuse me.
Should I-
Yes.
I can't hear you there.
Okay.
This is better than courtroom 1, but it's not, it's still a big courtroom.
Understood. So, Your Honor, my position is that this body of alleged science, the firearms identification, is not reliable. It's not the product of reliable principles and methods. It should not be admitted at all. I recognize that has been addressed by many courts across the country, and the courts in Florida have not been particularly receptive to the argument. So unless Your Honor is inclined to agree with me, I think that what Ms. Norton and I talked about is that the best way to address this might be to proffer the expert's testimony when that time comes and rule on it at that point. So.
Okay. All right, very good. So in light of that, I'm going to grant the state's motion to strike the Daubert hearing request, but I will allow defense to proffer before the witness testifies just for appellate purposes.
Thank you.
Okay, so just remind me that we need to do that before the firearms expert testifies. All right. So I'm going to grant the motion to strike. All right.
Judge, one more housekeeping matter. if I
Sure.
could. Judge, I hope the court has now seen that I erred yesterday when I filed my supplemental memo on severance, one addressing the court's question to me last week. When I filed a draft instead of the final memorandum,
Mhm.
I realized that very early this morning, immediately contact Ms. Ismer. And this morning at about 8:30 or maybe before, I filed an amended. Now, I will
Okay.
tell the court that the amended is in fact very similar to the supplemental.
Okay.
There's not anything of grave change to it, but I wanted the court to be aware that that was my mistake, and I apologize to the state for not catching it this morning. We filed a draft instead of the final of what we wanted to file.
Okay, very good.
Okay, and then the other thing, judges, I know I asked the court about this earlier in the week, believing that this would conclude any motions. I did have, and I will reiterate again, a motion in limine as it relates to the state's witness, Robert Howard.
Okay.
It is not yet complete, but it will not
Sure.
require testimony and probably very brief argument.
That's fine. We're going to pick another date in the future to hopefully resolve any outstanding evidentiary disputes. And I know you all still need to get together to do your evidence view, correct? Has that
Yes,
been
sir.
scheduled yet?
I was gonna talk about that today. I know
Okay.
because of the voluminous nature of it, I wasn't even sure the state was ready to do
Judge,
that.
We do have to, we've gotten some items out of evidence, but I think there are some additional physical items that we need to get out of evidence that were put in trial.
Right.
So we will get that done. I think the photos for the most part, we're just gonna reprint. But they are a lot of photos, so I do need some time, but we will schedule that.
So on the lunch break today, I need you guys to figure out a prospective date for that. And then I will set a motion hearing date after that. But we need to have at least an idea of when that's going to be, because I know your calendars are busy and I don't want you all to get jammed up and then we can't get together at least one last time to go over any and all outstanding motions or issues.
Yeah.
Okay. All right. And I know we discussed this on the state's motion in limine regarding victims, gang activity, and drill rap videos not disclosed in reciprocal discovery. Did I give you all an absolute deadline? Did I pick a date?
Judge, I think they were supposed to provide it to us today, by today.
Okay.
And Judge, that would be any videos that we intended to enter,
Correct.
any of us.
Yes.
And yes, Judge, you did give us until today to do so. On behalf of Mr. Murphy, I will not be providing the state with any additional videos.
Okay. All right. And so state, you're going to take a look at those and then let me know if you have an objection.
Yes, Judge, I believe the attorney for Mr. Chan provided us with a list of videos.
I
So
did
we will
see-
let-
Yeah, I did see that. Okay, so I'm going to actually reserve ruling on that motion pending the state taking a look at what's been proffered. And if I need to resolve a dispute, then I will do so, whatever our next hearing date will be. Okay? So that one I will reserve ruling on. Yes, Mr. Wise.
Gary, while we're talking housekeeping matters, there is, at some point today, I'd like to briefly readdress a question Your Honor asked during my traffic stop motion after having done a little research on it.
Sure,
I can do that now.
sure.
Okay. So
When we were having argument on that motion at the last hearing date, Your Honor had asked if I would agree that finding the firearm in the car that Mr. Guthrie was in would give a basis for, I guess, arrest. I don't recall if it was arrest or a search of the car because he's under 21. And I didn't agree with that for a lot of reasons. But having done a little more research, I don't see a basis. I don't see a reason why his possession of a firearm being under 21 and over 18 was unlawful. I know that's what the officers apparently believed, but I don't see a reason why that was unlawful. And if the state, has a reason that I'm missing, I'm sure they would bring it up. But to go back and readdress that question after having done some other research, it would, if he was under 18, it would have been unlawful. But I don't believe possessing a handgun
Under
between 18
21.
and 21 is unlawful.
Okay, state what's your argument.
Judge, Judge, it is securely encased. I think that he is correct, but there is a law for that. But what he was arrested for was the possession of drugs and drug paraphernalia.
No, I understand, but I think the argument was made, I think law enforcement took the position that was also,
They did, Judge. They believed that, and correctly so, that there is a law that if you are under the age of 21, you're not allowed to possess a handgun. But there is also additional part of that statute that says as long as it is securely encased, it's our understanding that that was in the console of the car.
so do you agree that would have been securely encased in the console of the car within the meaning of that statute?
Yes, Your Honor.
Okay, all right, thank you. Okay, all right. So next, we will move on to argument regarding the various motions as it relates to the gang evidence and whether or not it's going to come in. So the state has filed a motion for pretrial ruling regarding admissibility of evidence. And who's going to argue that motion for the state?
May I be heard, Judge?
Yeah.
Maybe, Your Honor, and again, strictly up to the court, having the defense argue their motions as it relates to limiting of all of those things might subsume the state's actual motion when they argue against the same.
Well, no, and I agree. I agree. Really, the point of the hearing the state first is for the state to articulate exactly what it is that they're intending to admit. So that's my motivation in asking the state at this point to proceed. It's for them to identify on the record exactly which incidents they are intending to introduce, and then I will have the defendants argue their various motions.
Thank you, Your Honor.
Okay?
Judge Campbell.
Sure. So if I'm looking at the state's motion, it looks like you're going back as far as 2018.
Yes, Judge, I am just looking at so many documents, just trying to find that one.
Yes, I understand. So it looks like pursuant to the motion itself, August 18th of 2018, Joe Rod Adams, also known as Spaz, was murdered at a Rains High School football game. Adams, it's alleged, was a 1200 associate. Robert Howard and Adrian Bibby Gaynor were suspects in the homicide of Adams. Howard and Gaynor are six block members, and Robert Howard was convicted and served a 5-year prison sentence for manslaughter and aggravated battery on that case. I believe Robert Howard was also a victim in this case, and he did testify in the Andrews case. The state also alleges or discussed in February of 2019, Adrian Bibby Gaynor was shot and killed in Jacksonville, Florida. Adrian Bibby Gaynor is known to be close with the victim, Charles Jones, and is associated with 6 Block. Hakeem Cusso Robinson and Leroy Scotty Whitaker, gang members of ATK, are currently charged with murder for the death of Gaynor. Then the state identifies August 16th, 2023. Jaquan Pickens, bully gang member, was shot multiple times and killed. Bully gang is associated with and allied with 6 Block. And then August 17th of 2023, there's an attempted murder of Jacoby Beals, a 1200 gang member. This shooting was believed to have been committed in retaliation for the murder of Jake Pickens that occurred the day before on August 18th. On October 7th, 2023, Antonio Tilley, ATK gang member, was murdered. Members from 6 Block claimed credit for the murder on social media. On the same day that Tilley was murdered, immediately after, there was an attempted murder committed against the victim, in our case, Charles Jones. So I'm assuming, are those all of the prior incidents of gang violence that you are seeking to introduce?
Yes, Your Honor. That's what was outlined in my motion that we responded to, the motion for severance for Rashad Murphy. It's also what we have listed previously in all the defendants' case as under notice of inextricably intertwined evidence, Judge. Along with, there are some drill rap videos that also mention some additional gang members that we also intend to introduce. And Judge, it is the state's position that those 6 incidents, as well as the drill rap videos that we have listed in discovery as inextricably intertwined and evidence of motive, is relevant to this case against all of the defendants. First of all, the 3 defendants, Isaiah Chance, Rashad Murphy, and Davian Murphy, are gang members, and as part of our requirement for proof for that particular gang enhancement, we have to prove that they were gang members and that this crime was committed for the purpose of enhancing or benefiting the gang in some way. And Judge, we are prepared to do that. As far as Sean Gathright, we believe that it is also admissible in his case. He is closely tied to Isaiah Chance, who is a known gang member. There is evidence that he is the supplier of the gun, as well as there is evidence that directly links him to the attempted murder of Charles Jones that occurred in October of 2023. We have listed the case law for this argument for inextricably intertwined that is directly relevant to gangs. In particular, I will again cite to that Richardson case what was very clear, that there were 6 prior shootings that was introduced in that trial. That was a gang case that occurred again up in Jacksonville, where a child was shot and killed, and his grandmother and another woman in the car along with him were shot at but unharmed. And what the court went through is this whole argument about inextricably intertwined, and the state in that case was able to show to the jury through the documentation by the gang itself, that's how it qualified these drill rap videos, was the fact that this gang war was documented by the gang members themselves on social media, by not only drill rap videos, by social media postings. All of that was evidence of motive, and the court acknowledged that that was highly prejudicial, especially the prior shootings, but it was not substantially outweighed by the probative value of motive. And that is what this is in this particular case. It is motive. It tells why in Richardson, why that baby was shot, because there were gang members that were standing on the street where that baby and his family were. And it provided the explanation why that shooting happened, the motive. And it is the motive in this case, that historical gang war actually will show the jury all of the reasons and give context to why this shooting happened. And so it is highly probative. Motive evidence in any case has a very significant probative value. And the court went through that analysis and said that that background, even the collateral crime evidence of the prior shootings, was not outweighed, that prejudicial effect was not outweighed by the probative value. And it is necessary for us to be able to actually explain to the jury what led up to this shooting, what was the motive, why they all came down to Tampa in one day for the specific purpose of shooting Charles Jones. And it all has to do with this back and forth gang war that is going on. 3 of the people of the 4 that are left are part of the gang that are allied together that dislike Charles Jones. Those drill rap videos, the evidence on social media that shows the back and forth, all of those are connected to these 6 incidences that we have alleged. In particular, Adrian Bibby Gaynor has a relationship the first one is the Rains High School where we start. Joe Rod Adams, I apologize, starting with that one in 2018, he had the nickname Spaz, was a gang 1200 associate, and is related to the Murphy. So obviously going back to that specific case, especially since Robert Howard, who is also a person that was with the victim when he shot and is a witness in this case, is relevant and gives history to the significance of the motive in this particular case.
Okay, and I'm not meaning to cut you off, and just so everyone knows, the first thing I really want to discuss and what I'm going to rule on today initially is regarding the introduction of the evidence related to the 6 specified incidents in the state's motion. All right, because then once I rule on that, then we can have a discussion regarding what drill rap videos and what other evidence is going to come in once I've ruled on the admissibility of the 6 previous incidents.
And Judge,
Okay.
I may ask for the assistance of Ms. Ismer. She has kind of taken over this area for us and covering with the state, and to some particulars, I may require her assistance in responding to the particular specific reasons why they're relevant to the case.
Okay, and that's, you mean as far as the drill rap videos or the actual previous incidents?
Both, Judge.
Okay, so yeah, so what I'm trying to say is that the any objections to any specific videos, I will address that after I've ruled on just the general nature of the gang evidence coming in. Once you all know the parameters of what's going to be admissible, then we can visit if there's objections to certain drill rap videos, whether or not they come in. Okay? Okay, very good. All right, anything further before I turn it over to the defense just with regards to the 6 previous incidents?
And Judge, I know that we probably will go through one by one, but some of the defense motion and limines that have to do with gang, there are several paragraphs that list different items. And so at some point, when we go through those items, I would like the opportunity to address those items.
Sure.
Okay. Thank you.
Absolutely. And one question. There was testimony that Joe Rod Adams is actually the brother of Davion Murphy. Is that correct?
Judge, there was testimony, I believe, by one of the detectives. They knew that there was a relationship. They had him referred to as a brother, but they were not absolutely certain as to whether it was a brother or a cousin. But they are sure that there is a relationship between both of the Murphys and Joe Rod Adams.
Okay.
But
And-
he did at one point believe that he was a brother to, I want to make sure, Rashad Murphy, and cousin to Davion. I now believe that is the reverse. Is that correct, Ms. Isma?
The only evidence that we have to support the relationship is that there's a familial relationship, that they are cousins. There was some discussion, but proof as far as setting that forward at trial of a brother relationship, other than referring to them as their brother, is.
So I was going to ask you, what is the state's proof? Unless the defense is conceding that they're related. Mr. Gonzalez? Excuse me. Well, it'd be Mr. Gonzalez and then also Mr. Sonardi.
I'm sorry.
Well, Judge, I think it's the state's burden
I agree.
to provide testimony and evidence that they are in fact related in some way, shape, or form. So I would ask the court to defer to their proof in answering that question.
Okay. Same, Mr. Sonardi.
Same for
Okay.
Davion Murphy.
I'm just asking the question. Okay. So what's your proof?
Statements are calling Mr. Joe Rod Adams.
Whose statements?
Mr. Murphy and Mr. Davion Murphy and Mr. Rashad Murphy refer to Joe Rod Adams as their brother
And was that in text messages or
in their interviews.
in their interviews?
Correct. More recently, there are phone calls which Davion Murphy has made with his mother, which indicate that the relationship is cousins. The detectives' evidence as far as following the gangs that they provided to us in preparing for the case were that the relationship established that they believed it to be was a cousin relationship. But the reference that we have is that they are brothers. I cannot tell the court whether that means that they are blood related or they just refer to each other as a brother.
Okay. Okay, very good. Okay, so who wants to go first?
I'll go, Your Honor.
All right,
Brian Gonzalez on behalf of Rashad Murphy. Judge, how the state of Florida gets to the point where they can elicit this type of evidence is the issue here. The second motion in limine, in addition to the Dahlberg challenge, requests that the court prohibit the admission of law enforcement opinion testimony and related evidence concerning alleged prior gang war history, hearsay-based gang intelligence, and purported uncharged gang-related incidents. It's our belief that the state is going to attempt to present to the jury a large and sweeping narrative that goes back 6 years, at least as referenced in the state's motion for pretrial ruling on admissibility, of a gang war in Jacksonville that includes multiple groups, dozens, if not more, of individuals, a series of shootings and homicides going back to, based on their motion, 2018. This murder being in June of 2024. The state argues that this evidence is inextricably intertwined and that it establishes an underlying motive for this particular offense, the murder of Charles Jones. And it's our belief that that is not supported by admissible evidence. Through what now appears to be three detectives, Detectives Nieder, Griffith, and McCullough, the state's going to attempt to introduce opinion testimony, which I submit to the court lacks or labeling historical violence as retaliatory conduct, and also utilizing a plethora and what is the primary basis of their testimony being hearsay-based intelligence derived from reports from other officers, confidential informants that are undocumented, lyrical interpretation of by opinion testimony of rap videos, a evidence of uncharged and unsolved shootings, wholly, by the way, unconnected with Mr. Murphy. And collectively, I believe it invites the jury to decide somebody's guilt, in this case, Mr. Murphy's guilt, based on association and propensity rather than admissible evidence. The relief I'm requesting in detail is on page 2 of my motion, and the court will read that in her ruling.
and I'm sorry, we on your second motion in limine or third?
It's number 2, Judge.
Okay,
To that extent, the state is going to have detectives outline a history of this conflict going back to 2018, most of which are unsolved, and none of which are alleged to have been committed by Mr. Murphy. There will be testimony from detectives about gang affiliation as it relates to Mr. Murphy, as it relates to Rashad Murphy, as it relates to Mr. Chance. And there won't be any, I believe, as it relates to Mr. Gathright. The testimony is also going to outline the gangs themselves, the nature of the gangs, inclusive of their background and their history, sometimes going back to their inception, long before any of these detectives were involved in their particular investigation of those individual gangs, collectively or individually, and also how these gangs are not traditional gangs, they're hybrid gangs. They have no hierarchy, they have no rules, they have no consequences, they have no punishments, and that is an important aspect when we talk about how they differ from a traditional gang where one member does things only at the behest of other gang members, or at the behest of the gang as a whole. There are individual motivations in these hybrid gangs that may not have any involvement, any other than an individual grudge or a particular issue between one person and another, that doesn't trickle down to any type of group gang type decision or plan. And that is the nature of it being a hybrid gang that mostly is derived historically based on neighborhoods or where you grew up. As it relates to testimony last week, Judge, and I'm going to run through this very quickly, Detective Nieder has 7 years on the job at the Sheriff's Department. He was assigned as late as 2022 to the gang unit. And at that particular time, he started working exclusively with ATK. He has taken 3 yearly courses at the beginner and intermediate level through HIDTA, HIDTA, and these are 3-day organizational crime conferences where general gang intelligence is discussed, and they also do not provide any comprehensive instruction. And this is based on testimony from Detective Nieder, whether it be at the hearing or sworn testimony from his deposition, and that's set forth in the motion with particularity as to where the court can find that. He essentially admits during his deposition that the majority of his training and experience comes from on-the-job training and based on what other detectives had told him prior to him coming on board. Although he alleges that he speaks with a number in a group and on a regular basis, community members, they don't openly discuss gang details to where they are documented, to where there are reports, to where there can be testimony as to who they are. And certainly those witnesses will not be testifying in court. As it relates to Detective Drabeck, I'm going to pass him, as I understand by the court's ruling, that he's going to be testifying to this particular investigation in and of itself and will not be testifying to any historical information. As it relates to
Correct,
Detective...
not as a gang expert.
Correct.
He's a fact witness.
Yes, Judge. As it relates to Detective Griffin, he has been with the department for 16 years, but he didn't join the gang squad until 2021. And for him, he's been through that same HIDTA training for 21 through 24, 4 weeks total. And he has never been qualified as an expert or given testimony as an expert. And essentially, he pretty much says the same thing as Detective Nieder says, acknowledging that his knowledge of 1200's activities prior to 2023 is very limited. And he does not have any witness with firsthand knowledge of any group dynamics. All of his testimony, again, is contextual inferences by unknown individuals that he cannot document. He can't tell us when, he can't tell us who, and he can't tell us with particularity what they say. As it relates to Detective McCullough, he began in 2022, and essentially he is in charge, and that's after a long standing history with the department itself, but again, in 2022, January, and he became assigned to 6 Block. He also went through the HIDTA training. He also went through and did a couple of other trainings of general types, and talks about how social media downloads, rap videos, interaction, again, with community members would be his source of information, again, with no particularized documentation of any kind in any way, and would not be able to testify to that if given an opportunity to testify to these historical issues. He also had some, he was unsure exactly if he'd ever testified before as an expert. He does recall testifying a couple of times. He thinks just in front of a judge and the state attorney, which might lead me to believe it was either a motion or a sentencing. Doesn't appear that he's testified as an expert as it relates to any type of trial testimony.
Well, let me just ask the state something. Who are you intending to call as your gang expert?
Judge, three witnesses, Detectives Meter, Griffin, and McCullough. They each are specialized in a particular gang that is involved in this case, and all of them have years of experience in that gang unit monitoring these gangs.
So, but we can't have cumulative testimony.
Correct, Judge, and we will not, it will not be cumulative. There may be one or two that we cover it all with one or two and not call the third, but we have just listed them under the abundance of caution if there's something that one of them cannot speak to.
Okay. We'll cross that bridge when we get there. So,
And Judge, it's my expectation that we will rely on one of them mostly for the expert testimony, but as far as the documentation, there is documentation. Each one of those gang members have been documented with field incident reports that are maintained by the specific person assigned to that gang. So there is fact-related evidence as well. So we are not intending on offering cumulative evidence.
okay.
And Judge, what I anticipate Ms. Doherty is talking about is a particular report where a person is documented as a gang member pursuant to statutory criteria. That we're not talking about testimony from people as to their gang history and what they do and what they did and what they might be accused of doing and how they relate potentially to a particular murder or a particular shooting. None of that. What Ms. Doherty, I believe, is talking about is the singular report where a particular person is documented as a gang member and under these criteria. And certainly you look at those criteria, and in and of that criteria are unknown interviews with unknown people.
Sure. So, but there's two separate issues here, right? Okay. So what we're discussing right now is the historical
Agreed.
evidence.
I
That's all
agree.
we're
I just wanted
discussing.
to respond to.
Yeah, no, that's fine. And that's what I'm focused on right now.
Understood.
What's the parameters of the historical evidence that's going to be permitted to come in? And three of the defendants, the state has identified for aggravators as being gang members or associates.
Correct.
And so that's a separate issue as far as the state's proof and who they're going to call to establish that. Okay. So I just want to make sure that we're clear what I'm focused in on at this particular moment is the history and how much of that's going to come in.
So I'm mistaken, because I thought Mr. Gonzalez said he was on to his second motion in limine, in which he's challenging the expertise. So
We are.
We are, and we'll get there.
Okay.
We'll
All
get
right.
there,
I
but
apologize, Judge.
I'm going to first deal with the issue of the admissibility of the history of the gangs in Jacksonville.
Yes,
Okay?
Judge. So in my motion, and I'm not going to go into it because I want to get to other things, I give the court what I believe, based on testimony of detectives at deposition, the backgrounds as to each one of the gangs themselves, 1200, ATK, 6 Block.
Because there are a lot of incidents, it looks like in your motion, Mr. Gonzalez, that the state's not seeking to introduce evidence.
They are, Judge, but they were testified to at deposition, and we did not know until we got this
Yes.
motion
Okay,
for
that's fine.
admissibility.
So, because at this point, the state has identified 6 instances, 6 historical events, and that's the universe at this point of what the state is seeking to introduce.
And
So,
I'm going to just touch on each one of those.
Okay.
Only those 6, not all the ones that are in the motion, because when the time I wrote the motion,
Right.
we weren't there.
Okay,
So I will
very good.
touch on those very briefly because they are in much more specificity and particularity in the motion. But I'm not going to just track the motion. I'm just going to try to give
Sure.
some bullet points on each one of those circumstances.
Okay, thank you.
The gang war narrative, Judge, they are all listed, inclusive of the 6, in the table that I have in the motion. And I just would ask the court to look at that table. Now you can cut it down to those 6. Just gives an overview of each one of those circumstances. As it's reflected in each one of these detectives' testimony, many of those incidents remain unsolved. Certainly, in trying to determine who might be associated with what, there's not enough evidence to charge anybody with anything. None of these defendants, no one else that might be associated with any kind of gang. And therein lies, even at its root, a problem with what they would like to testify to as it relates to opinion that can't be buttressed by what I believe is admissible evidence, especially as it relates to Mr. Murphy. The states can introduce law enforcement testimony that establishes a victim, that talks about a perpetrator's gang affiliation, but no testimony about any one of these individuals specifically involved in any one of those circumstances, except for maybe some testimony as it relates to Mr. Jones's attempted murder on October 7th, because they're going to take a leap and they're going to talk about Mr. Chance and potentially Mr. Gathright, but mostly Mr. Chance. Without establishing this gang association, and I don't mean criteria under 874, I'm talking about evidence from witnesses. I think the state's intent here is to try to fill this evidentiary gap with testimony from one or more of those detectives, and they're going to cloak it as expert testimony or opinion. But regardless of whether it is, it's based on hearsay, it's based on speculation, it's based on contextualized inference, none of which is admissible under 702. So I asked the court to make that correlation as you determine these issues. Of the 6 incidents that we're talking about, take a quick glance.
Sure. So just again, to recap, August of 2018, the murder of Joe Rod Adams.
Mr. Howard was convicted of manslaughter in that
Yes,
case.
he was. And will be a witness in this case, correct?
Oh, he will be a witness, and certainly we'll have an emotion in limine on that. And I would, based on his deposition and based on his proffer, waiting to hear what he might say on the stand under oath about gangs.
Okay. Well,
and about gang association.
And again, the only reason I raise that is because that's actually someone who will be testifying with direct knowledge of these incidents, right?
Direct knowledge of what, Judge?
Of the, he was convicted and served a 5-year prison sentence for the manslaughter and aggravated battery.
Yes, I believe he will testify under oath that,
Right.
in fact, that's the case.
Which means he can be cross-examined.
Correct.
Which is my point.
Yes, Judge. And now what other contextual knowledge he may have about anybody here or gangs in general?
No, I
that's
know,
another
I know.
story.
I'm just trying to draw the distinction between at least that incident. The state will have some direct evidence with a witness who then can be cross-examined, right?
Yes, Judge.
Okay, all right.
Now, I don't believe it will be as it relates to evidence that I'm suggesting in this motion is inadmissible or not inextricably intertwined. But nonetheless, we get there when we get there.
Right.
Judge Adrian Bibby Gaynor, Hakeem Kesu Robinson was charged in that case.
Right, and that was from February of 2019.
Yes, Judge.
Okay, and then we move on to August 16th of 2023.
Yes, that's Jake
Pickens.
Jit Pickens. That case is unsolved. Jacoby Beals is unsolved.
And that's from August 17th of 2023, correct?
That's correct, Judge.
Okay.
Then October 7th, Antonio Tilley, Jawan Mills was convicted on that case, but I don't believe there's any gang association based on testimony from detectives, and I'll get to that when I get to that individual case. And then we have October 7th, which is Charles Jones attempted murder. Right. That is unsolved as well.
Okay.
So, Judge, while it might be reasonable to attribute some level of reliability to law enforcement intelligence that's derived from social media, in this instance, the basis for opining that groups, either in rap videos or in social media that no one's going to be able to testify to, right? Other than there was some. When, who was on it, what date, who said what, none of that the detectives are capable of testifying to. They can't testify to a rap video and their own speculation and their own opinion as to what that rap video might say. But when we talk about taking credit for something, because that appears to be a big issue, taking credit. The court might remember that Detective Nieder testified that taking credit is actually trolling. You're trolling the other side. You're disrespecting the fact that that murder occurred. You might even be lauding that that murder occurred or that shooting occurred. And certainly the state would like you to take the leap or allow a jury to hear or allow somebody to testify to, that's an admission of committing a crime. And I would ask the court to look very closely as to whether or not that inference is admissible. Essentially, just briefly, Detective McCullough, when asked, are you saying they're claiming credit for some of these shootings? What do you mean by that? Well, they'll get on social media, Instagram or Spaces or Clubhouse, which is like a social media platform, and they'll just start talking about it. He got what he deserved, stuff like that, just claiming, basically taking responsibility for it. None of that insinuates anyone is taking responsibility for anything. They are rapping about it. And he says that in one part of his response, but then would like to suggest that basically they're taking responsibility, which again is an inadmissible opinion on his part that's not buttressed by any evidence. No one is specifically saying I did this. Well, of course, as we talked about, nobody gets on a video and says, I killed this guy. And I guess that's not what I was asking, but his answer is correct. People are not saying they're just taking credit for it. So what's happening in these social media posts and sometimes in these rap videos are the same thing that's happening at the same time out in the community. Somebody gets killed. There are thousands of people talking about it. People hate it. People like it. People laud it. People think it was deserved. People know what happened. So-and-so got shot. So-and-so was walking down the street. This is a community whereby social media, the ability.
That's me pausing. Who is this right here next to him? Who is this attorney? Is he the grandfather or who this be? With these glasses right here. I wonder what part does he have to do in the case? I don't know. He look like, I don't know. God bless his soul. He's still in there. He's still moving and still doing it. Wow. Oh, wow. Oh, wow. So that's Chance. That's the one with the BDB nappy, the little boy here. He look like he got a little boy here, like he a little kid. Oh, you know what I wanted to tell y'all? You don't know? You do not know? Guess what, guys? I got a jury summons in the mail. I don't know. I don't even know how they even figured this out to even send this to me. You just say, failure to respond is punishable by law. And I'm like, well, what do you do for the people that don't check their mail? Well, anywho, it's in Arizona, of course. Maybe I'll get on Nancy's case once they catch her killers. And I could be on Nancy's case and I could be a juror. Yeah, that might be nice. I don't know no big trials that's coming up that I would want to be on here. So, all right, here we go, guys.
To have knowledge and information is quick. And detectives testified to that. This is not relegated to one single group or one single person that knows about what happened to somebody. It's what they say about it. And therefore, we have to be careful. I believe the court has to be careful not to suggest to the jury and not to allow evidence that would lead a jury to believe that somebody had something to do with something when that's not what they're saying.
Right, I agree.
Judge, talking specifically about the 6 instances, I'm trying to talk as fast as I can. Joe Wright Adams.
Right.
The state is going to suggest that there's evidence to believe that Joe Wright Adams is a cousin of Rashad Murphy and Davion Murphy. This occurred in August of 2018, 6 years prior to this particular case. Detective Dishman was the lead detective in that case. In her deposition, she actually said that in investigating this case, that the argument developed over a girl, and it escalated. And at one point in time, Mr. Howard, a state witness, told a person, somebody's going to die on my 8. And then Dishman testified that she believed that Howard was talking about his friend, Lawrence Davis, who's called 8. That's the evidence of this gang affiliation in my mind. What ends up happening subsequently is that Bibby Gaynor is alleged to be a second shooter. He's not charged. Mr. Howard ends up either taking the rap or pleading guilty to a manslaughter on what was an alleged first-degree murder. And essentially along the way, the whole case falls apart because people recant what they were saying. They say they weren't telling the truth.
Right.
And they say they got threats. None law enforcement can't corroborate any of these claims.
Well, let me see this, Mr. Gonzalez. Let's just assume the state has evidence, enough evidence to go before a jury to make the argument that Joe Rod Adams was in fact had some close relationship. They whether or not they were actual family members, maybe referred to themselves as family members, whatever that may be. Wouldn't that be direct evidence potentially of a motive involving Davion and Rashad Murphy?
No, Judge. I think we have a significant remoteness involved. I don't believe that the jury should be led down a path that simply because one person was related to another,
Right.
that would provide the modus
Well, let me ask
to
you
kill
this,
somebody 6 years later.
and remind me, and I may be getting, because I may be misremembering, but was there not a video that Mr. Jones is performing in, or someone affiliated with Mr. Jones, where the grave site of someone's being desecrated? Am I remembering that correctly?
You are, Judge, it's another incident though, that's the town center shooting, but
Okay.
there are references, sorry, I'll let.
Yes, Your Honor, that is correct. And it is of Mr. Joe Rod Adams.
Right.
Gravesite.
Right. So
That is
Joe
separate
Rod,
part.
right, Joe Rod Adams, and again, I'm just assuming for the sake of argument that there is evidence that there is some close relationship between the Murphys and Joe Rod Adams. He's murdered, and then Charles Jones actually makes a video where I think that they're pouring alcohol or something on the gravesite.
That's correct, Your Honor. So there was an initial video where it's believed that someone was urinating on the gravesite.
Right.
And Mr. Jones is alleged to have taken that a bit further and made an actual video with beverages or something.
Yeah.
Report on the same.
Yeah, I mean, okay. I just want to make sure I'm getting my facts correct.
And Judge, that's addressed in the motion when you get to it. As it relates to Bibby Gaynor, February 15th, 2019, 5.5 years prior to this murder, essentially, Mr. Gaynor is allegedly, well, not allegedly, he's killed by Hakeem Robinson, and essentially Detective Oliver was the lead detective in that case. He was deposed. That was unsolved for about 18 months. Only at such time as a jailhouse snitch came forward and gave information that connected that murder to some type of retaliation, that law enforcement was able to make that connection and attempt to run with that particular theory of prosecution or theory of the murder. At this particular time, I don't believe that person is going to be testifying. It's hearsay. I don't believe that anybody is going to hear from a person who had direct knowledge of what happened or why it happened or under what circumstances it happened. I think that Detective Drabeck in his deposition stated that as it relates to Gaynor's murder, that although he was a suspect in Adams' murder that he wasn't charged with because everybody recanted, that he opined that Adams' murder was not the nexus for Bibby Gaynor's murder. That's what he says on page 29 and 30. Instead, he believes that the murder happened out of pure opportunity, not revenge, not retribution. And that's his sworn testimony.
State, just real quick, what's your response to that in regards to?
Your Honor, since the depositions have been taken of those detectives. Queso or Hakeem Robinson, very prominent ATK member, has since been convicted of that crime. And so understanding the defense's argument that the weight of that evidence could be that there's some other reason why that killing occurred, it is yet another act of violence which occurs months after Mr. Howard is arrested for the murder of Joe Rod Adams and killing the other person suspected to have been involved. So the 2 6 block members that are allegedly involved in the homicide of Joe Rod Adams in 2018, one of whom is arrested for that murder, the other of whom is killed in February of 2019, and then obviously now subsequently convicted of that murder.
Okay, thank you.
Judge, next briefly is Antonio Tilley, October 7th of 2023. Tilley, there'll be testimony from detectives again. And I'm not going to go over each time when I talk about testimony from detectives. The court already knows my feeling on how this testimony is going to be elicited from detectives and where they get the information. And I think at the root of the problem, it all is the same. So I'm not going to say that every single time, but every time I mention a detective and every time I mention what that detective is going to testify to, it's really under the same circumstances and same ability that he's going to be testifying to. Somebody else told him that we don't know who it is. Some social media post said it. Some Instagram Live said it. It's not documented. There's no report. There's no witness that's going to testify to it.
Can't gang experts testify to that?
No, Judge, I don't believe they can. Okay. Tilley was supposed to be an ATK member. Detective Anderson was the lead detective. Essentially, this was a contract killing. That's what the detective said who investigated the murder. And essentially, it was done by Jaquan Mills. Jaquan Mills is not a gang member. To my knowledge, and based on testimony from detectives, Jaquan Mills is not affiliated with any gang. Essentially, as I understand it, Detective Anderson testified that the suspected contractor is a guy named Paul Anderson, who is now doing a 25-year sentence for drug-related activity. I don't believe there's any indication that Copeland or Anderson are related to 1200 or 6 Block, at least on any basis I know, unless somebody's going to testify to it now, and probably under the same premises that they're going to testify to everything else that they testify to. Anderson then did defer to Detective Nieder in his deposition, and essentially he said, my understanding is that Detective Nieder suggests that Tilley had something to do with Sedarian Copeland's son being shot. So that's potentially the reason all this occurred. We now get to October 7th, 2023, which is Charles Julio Jones. Obviously, that case is unsolved as well. Now we start dovetailing into evidence I believe is, in fact, potentially admissible against one defendant and shouldn't be admissible against others.
Which is what?
Which is Nibin matches between the shell casings recovered on October 7th at the scene and casings found in Sean Gathwright's vehicle. And essentially, Detective Nieder, based on the same analysis, is going to say that Jones was shot in retaliation for Tilley. And he believes that Isaiah Chance was involved. And his opinion is that Chance and Gathwright were close friends, spent a lot of time together.
Well,
and,
the state's not going to be able to get into that.
well,
It's unsolved, and Detective Nieder is not going to be able to opine that he thinks Isaiah Chance was involved in the attempted murder of Charles Jones.
well, that's been what's been suggested up to now. And
No.
am I mistaken? I'm mistaken.
Judge, we wouldn't go into that sort of opinion testimony. We do plan on presenting the physical evidence that ties him to that,
Yeah.
as well as any statements he made through other, but not through the opinion of
Right.
the officer. They have not charged it.
Not relevant to Mr. Murphy and not admissible to Mr. Murphy.
Well, it's a conspiracy charge.
Judge, again, we'll get to that because that's what the supplemental,
Well, that's a separate issue. So
right,
let's just
supplemental
stay
issue.
let's just
Yeah,
stay
Judge,
focused. So listen,
detect-
no gang. If the state calls a gang expert, whoever it may be, they're not going to be able to opine about culpability of anybody who hasn't actually been charged or arrested or proven guilty. So that's not going to happen.
Okay, because certainly Detective Nieder was very clear when he said that Chance was upset with ATK.
Well, I understand. Law
Got it.
enforcement says lots of things in depositions that never come before a jury.
Understood. That's why we want to make sure that that's
Yeah,
covered in a
it's
motion
not.
like this. Judge, in an incident by incident review, in addition to the other incidents that are set forth in the motion, but they don't matter anymore. Let's take these 6. We believe that it establishes that the state doesn't possess witnesses with firsthand knowledge capable of establishing gang membership, internal group dynamics of the gang, retaliatory decision-making, or coordinated action amongst these groups. Part of the reason being that they're hybrid groups and nobody is accountable for anybody else. And that is clear by the nature of the detective's definition of this type of association.
Sure. And I indicated in my email yesterday that you all would be given 20 minutes each. So I haven't been timing you, Mr. Gonzalez, but
I hope
I'm
you're
sure-
not, Judge. Don't start now.
I am not, but I'm sure the other counsel would like a chance to weigh in. So I'm going to give you 5 more minutes.
Yes, Judge. Your Honor, when we talk about Hayes and Richardson as it relates to,
The admissibility.
yes, Judge, which is part of a large part of this, the severance issue as well as the intertwined evidence. I think that, Hayes and Richardson are co-defendants.
Correct.
They were tried together, but with separate juries, notably. And essentially,
Because of a Bruton problem.
Judge, there's no Bruton problem here. There's no antagonistic.
No, I know,
defenses
not in
here.
our case. In Richardson Hayes, there was a Bruton problem, which is why they had 2 separate juries, but the case was tried together.
And Judge, although the evidence is similar as to both of them, I think Hayes is a little more illustrative in its opinion. And essentially, in that case, what I want to make sure the court understands, my position, that this is a feud between PCE and 187. You've already heard, things about that, so you can understand the interrelationship. And essentially, these 2 gangs got sideways at a Kodak Black concert in November of 2015. And essentially, that spawned a street war between them that lasted approximately 76 days. And those are the intertwined evidence that the state admitted over objection in that particular case, which is a far cry from the level of alleged inextricably intertwined evidence in this case.
Well, in the Hayes case in particular, and for the record, we're referring to 338 7th 3rd 1123. In that case, the specific time frame as far as the historical gang evidence that was admitted was November 25 through January of 2016. That was the specific time frame. And I would just note for the record that in the Andrews case, I did allow Detective Nieder to discuss, I believe, the incidents of violence from which kicked off in 2023. Like you had the 2 incidents in the 2018, 2019 timeframe, and then there really appeared to be relatively quiet. And then in 2023, the violence cropped up again. So with regards to Ms. Andrews, I did permit Detective Nieder to testify to the history from the 2023. And I do believe, because Mr. Howard testified, that there some evidence regarding the killing of Joe Rod Adams came in because he was actually a witness. So,
Fact evidence as to his involvement in that murder.
Right.
Judge, the big difference here is that in Hayes and Richardson, firsthand knowledge, there were multiple witnesses that testified that the defendants were members of gangs. They were members of the same gangs. They interacted with the defendants, in this case, Hayes and Richardson. In fact, Mr. Bradford testified to what their street names were. He testified they were both known as shooters in the gang and had participated in shootings in the past. That he, on many of the photographs that were entered, was able to say, I know that photograph.
Well, I agree. In that case, I don't see, and I'm not sure if the state called a gang expert or not, but in the reported opinion, the history of the gangs came in through gang members, correct?
Yes,
State?
Judge.
Yeah.
which is the way it should be.
Well, that's why I asked you if gang experts could testify to that, and you said you didn't believe so.
No, Judge, I don't.
Okay,
I-
so I'll hear from the state on why gang experts can testify to that.
And so, Judge, if you court's read the opinion, you're not going to give me much more time. You're glaring at me. I get it.
I'm not, for the record, that's not a glare, Mr. Gonzalez.
I didn't want the record to
That is
reflect that.
It's just a mindful look.
Yeah, Judge, and I didn't want the record to reflect that actually as it was said. If you go through those two cases, with Hayes being a little more illustrative, you can see the 180-degree difference between those cases and these. And one of the major arguments of Mr. Murphy is that in circumstances like this, that's what the state needs. They need a firsthand witness to corroborate. They corroborated the videos that were admitted, the witnesses, the firsthand witnesses. They corroborated the photographs that were entered. They went so far as to be able to corroborate the car that was stolen and used in the murder because Mr. Bradford, the witness, supplied it. They were to the defendants. They were able to corroborate the gun that was used.
And I don't disagree. It's a separate issue. So
Judge, at the end of the day, again, I would rely on the motion and the particularity it sets forth, and essentially tell the court that the state can only establish the connection between the charged act and the prior act by relying on the detectives, in my estimation, I believe buttressed by the case law, improper testimony of lyrical interpretations. We skipped through that part, but it's in the motion. And what somebody thinks something says without it being coded language, without it being a circumstance where this language is used over and over and over and over again, which would allow an expert to testify to it. I do not believe that any of these detectives should be allowed to testify as experts based on the arguments that I've made and also those that are in the motion. I've included their depositions, Judge, which I think are really instructive when they're talking at length about their jobs and what they do and how they do it and how they get their information. I don't think the court has to rely on me. I think it's very clear in the depositions under oath. And finally, Judge, that they are drawing these clues from songs that are released by artists that are commercially viable. They can't establish gang affiliation other than maybe by 874 criteria, which I think is different than testimony that would allow this evidence to be relevant and admissible. And especially to show that there's a motive for these killings, it should be done with competent, non-hearsay evidence. And those prior acts are rendered irrelevant when they're not done that way.
okay, very good. Okay, let's see, Mr. Sonardi, do you have a motion as it relates to Davion Murphy on this topic? Or have you adopted Mr. Gonzalez's?
Correct. As to the 6 prior acts that the state intends to introduce, both as to Mr. Rashad Murphy and Davion Murphy, we will adopt the arguments of Mr. Gonzalez on behalf of Rashad Murphy, and also add that we can establish that Mr. Davion Murphy was basically incarcerated either in the Jacksonville County Jail and Florida State Prison from 1916 until almost to January 2023.
Do you mean 2016? You
Yes.
said 1916.
I apologize.
2016.
2016 until January 2023. The same argument as provided by Mr. Gonzalez on behalf of Rashad Murphy. Mr. Davion Murphy is not alleged to be a suspect or anything in either of the 6 prior acts that the state intends to introduce. I concur also in the evidence that's available to even establish that Mr. Davion Murphy is in fact even a gang member of 1200. Again, he was incarcerated, the 5-year window under the statute that expired. He is at most an associate. So again, we submit that contrary to the state's position, that introduction of those 6 prior acts as it applies to Davion Murphy would be so highly prejudicial as to not to overcome its probative value. We would ask the court, as to Davion Murphy, to exclude that testimony.
Okay. And Sean Gathright, defendant's motion in limine to exclude collateral evidence. Mr. Wise.
Your Honor, I guess before I begin, maybe for point of clarification, there, as you've heard, casings found in Mr. Gathwright's home that not even matches to 2 prior incidents. I think the only one that's of the 6 we've discussed is the prior Charles Jones shooting. So
Correct.
I don't know if the state it sounds like the state may not be seeking to admit evidence regarding these other 2 alleged incidents, one of which I don't think they know what or who the target of was. But could I just ask if do I need to address the Byron Walker incident and this unknown shooting from 2022?
We can speak to that. All the knife-in correlations to the other shootings from the traffic stop as well as from the safe of Mr. Gathwright's house, we are not going into. The only ones that we are going into were the ones that were actually confirmed, not just knife-in, but FDLE
Right.
matches
For
to-
Mr. Jones.
Correct, the
Okay.
attempted murder, and then to our case
Yeah.
here.
Okay, so that streamlines it a little bit.
Okay.
So, Your Honor, Mr. Gathwright's a little bit differently situated because he's clearly not a gang member. No one's even alleged that he was a gang member. As you heard from all of the alleged experts who testified, I guess it was last week, none of them had even heard of his name prior to being contacted by Detective Ramos. The only connection that the state has as to Mr. Gathwright is this allegation that he was friends with Isaiah Chance. And even that, I think, is pretty speculative. There clearly were communications between Mr. Gathwright and Chance, but I believe there's some thought that they must have been best friends. And I don't even think there's evidence to support that. The only thing connecting Mr. Gathwright to these gangs is his communication with Chance. And quite frankly, I think that the connection between Mr. Chance and the gangs is pretty speculative as it is, but that's the only connection. So he's clearly not a gang member. And I don't believe he can even really qualify as a gang associate just based on the fact that he's communicating with Chance. But that.
Well, the state has not identified.
No.
And then, as far as I can tell, they're not seeking to prove that Mr. Gathright is a criminal gang member or associate, just a member of a conspiracy involving other gang members.
Just, we're not approving an enhancement against him, but he certainly qualifies as an associate by the new statute with his association with Isaiah Chance. And Judge, we believe it's the jury's decision to ultimately find who is an associate and who is a member.
Okay. All right.
And again, Judge, if that's the case, then basically everyone Mr. Chance has ever talked to is a gang associate. I know that's probably a separate motion, but when we talk about relevance of all these other prior gang activities, the only connection, again, to Mr. Gathright is the fact that he's communicated with Isaiah Chance. Talking about each one specifically, the Gerard Adams incident, Mr. Gathright would have been 13 years old, I believe, when that took place. The Bibby Gaynor incident, he would have been, I believe, 14 years old. There's nothing connecting him in any way whatsoever to the Jaquan Pickens incident. Same with the Jacoby Beals. And the Antonio Tilley. The only connection, again, with the Charles Jones incident that takes place on the same date is the casings that are found in the Niven matches. But as you heard from the detectives last week, Mr. Gathright was not even on their radar in that case until the casings came back. So it's really just the mere fact that these casings are in the house. There's no explanation as to how they got there or whatnot. And there are, by the way, as you heard, there's a substantial amount of firearms and firearms evidence within the house that's searched. So that, Your Honor, I believe the relevance, whatever relevance would have all these incidences, and really the only one as to Mr. Gathright that could have any relevance whatsoever is the Charles Jones shooting. But the undue prejudice would far outweigh whatever relevance that evidence might have. I cite 2 cases in my memorandum that I think are remarkably similar to what we're dealing with here. And looking back now, I probably should have reference them with regards to the severance issue too, but it's Thomas and Gilly. And it doesn't appear that these were cases that involved gang issues, but it was very similar in that there are prior shooting incidents involving allegedly rival drug dealers and then their associates. Maybe they were even were connected with gangs, but it's taking the gang word out of it. I think it's really the same exact situation we're dealing with here. There were prior shootings, and then someone is killed in one of these prior shootings, and then there's a shooting that takes place of this prior victim's associates, and then a bystander is killed. So when the defendants were being charged with the shooting of the bystander, and Gilly, and it's not clear why he was severed, but he's severed and tried separately, the state brings in evidence of all these prior shootings, and that goes up on appeal after everyone's convicted. And in both cases, the second DCA says these instances were not necessary to describe the shooting. It was a pretty straightforward, the allegations of the crime they were actually being tried for were pretty straightforward. The courts found they did not need to get into these prior shootings to describe what took place. And it became, as I fear will happen here, a feature of the trial. And for those reasons, both of those defendants' convictions were reversed. And again, I'm not sure why they were severed, but it would appear that Gilly may not have had involvement in these prior shootings. I don't know if that's the case or not, but for whatever reason, he was severed. And it appears, based on my reading of those two cases, it may have been for that reason. But all this prior evidence comes in both cases, it becomes a feature, and in both cases, the convictions are reversed. And I think it's really the same exact situation we're dealing with here, especially as Mr. Gathright, because he really has no legitimate connection to any of these gangs.
Okay, very good. Thank you.
Judge, we would adopt that argument on behalf of Mr. Rashad Murphy as we would in all other defendants' arguments.
Sure.
Same here on behalf of David Murphy.
All right, very good. Mr. Petratus.
We filed our own motion, but we would adopt the motions of Mr. Gonzalez and Mr. Wise and their arguments, and I'll try not to be too repetitive.
Okay, and this is Isaiah Chance's. It's titled Defendant's Motion to Exclude Inextricably Intertwined Evidence at Trial.
Yes, Your Honor.
Okay,
And
go
just to
ahead.
go over the murders again very briefly, we have one from 6 years ago, the Spaz shooting, which is a alleged 1200, not ATK, of which Mr. Chance is purportedly a member of. And I think it's important to know that Robert Howard, who's, as the court is aware, is going to testify, at his deposition denied being a gang member of 6 Block. So I understand that they're going to try to get it a different way, but they're going to get someone here, like Mr. Gonzalez stated in the Richardson Hayes case, but this time this person's going to say, no, I wasn't a member of 6 Block. Then we have a 6-month gap. We have the Gaynor shooting. That is alleged, well, it's not alleged, it's a charge of ATK. The next 4 that all occurred in 2023 are all unsolved. And no one is going to testify as that was involved in any of those shootings. You're going to have no gang members to come here and testify to that. In the Pickens, in the state's motion, it says ATK is believed to be involved. Again, it needs to go back to Detective Nieder. And the court asked, the court said you can't opine on someone who committed a crime that we don't have conviction. And I would argue that you can't opine the gang affiliation of a person who we don't know committed the crime. You can't, it's another step that requires Detective Nieder to opine. Detective Nieder, in his deposition, stated he gets his info mainly from social media. He does talk to gang members, but he gets general information, not specific information for them. They're not confessing to crimes for him. That's not what's happening. He's just getting general background information from them. And I would argue that's not enough to come in and tell us who committed these crimes and say it's ATK, it's 1200. The Beale shooting is alleged to involve 1200, not ATK. And as Mr. Gonzalez stated, the last Charles Jones shooting has not involved a gang at all. They're going to say that Mr. Gathright is an associate, but again, that involves being friends with one gang member at the most. In Richardson, again, it was 76 days, and the court said this was a continuation and consequence of preceding events. And I'm going to argue that 6 years and 5 years ago. There's not preceding events to this crime. I would argue even, we have an 8-month gap between the last event in this historical gang war and this shooting. The court mentioned Griffin in the Richardson case. It said, to prove its case, the state is entitled to present evidence which paints an accurate picture of the events surrounding these crimes charged, In the Richardson case, again, 76 days. That happened one after another in a 2.5 month period. That is not what we have here. Richardson, one of the reasons they allowed it in, from my reading, was that they wanted to get the state why these victims were in fact the victims. We had a toddler and we had two elderly, or maybe not two, but an elderly grandmother and a middle-aged lady, and they wanted to explain how they could be the victims in that. That's not the case here. We have someone, Charles Jones, who is not a random civilian. There's going to be gang evidence presented about Mr. Jones. There's going to be gang evidence presented about all the co-defendants. There's going to be evidence of their involvement in the gang, testimony of a rivalry between ATK 1200 and 6 Block, all without the need to mention any of these prior shootings. The motive can be clear through the state's evidence without having to mention any of these shootings. And I think that's what the court should require. One other thing that hasn't been mentioned is these cases mentioned it cannot be a feature of the trial.
Correct.
And I find it hard to believe that if the state puts on 3 gang experts and then all the witnesses, and I'm going to use witnesses in quotes, to come in here and testify to show the other murders 6 times, that's days. It's
Well,
days of testimony.
No, and I do just have a little experience because the Andrews case, that's not what happened. Detective Nieder testified in his capacity as a gang expert, just historically, as far as the history of the gang violence. The state did not bring in, my recollection, any witnesses other than Mr. Howard, who was a victim in this case. So.
Well, we're talking, and I understand that, but I think that's going to be different in this case because I think they're going to try to bring in more.
Well, we'll see. You're right. It cannot become a feature of the trial.
And I find, I understand, but I just find it hard to believe it will not end up being a feature of the trial. If we're talking about 6 other murders. I don't know if that's exactly what happened in the other case, but everything else that I would get to is either in my motion or has been stated by the co-counsel. So that's all I have here.
Okay, very good. All right, state any quick rebuttal just as to the 6 previous incidents that the state wishes to introduce
Judge,
into evidence.
Judge, we are certainly not going to make it a feature of the trial. We do plan on calling one detective to really go over the historical gang war, so it will not be a feature. However, we are going to add
And who's that going to be? Do you know?
Judge, we believe it's going to be Detective Nieders. The other 2 are listed because we still have to show gang enhancements and stuff of that nature, and I do believe their expertise adds
Sure,
to.
that's a separate issue.
That's a
And
separate issue.
in the indictment, the state did specifically allege that Isaiah Chance, Rashad Murphy, and Davion Murphy were either criminal gang members or associates.
That is correct, Judge.
Okay, but not Mr. Gathright.
We did not, Judge. But Judge, there are going to be, I know that Mr. Gonzalez has kept saying like this is all based on hearsay. That is not true. There were some additional witnesses that were listed that were involved in those 6 other cases. And again, it's not going to be a feature. What I plan to do, Judge, is to have either a first responder just testify briefly within 2 to 5 minutes that they responded to that homicide, who the victim was, and then the gang expert is later going to connect up that victim was actually a member of one of these gangs. And then the next day, these are real things, real facts, real deaths that did happen. And the victim of one gang is killed. And then the next day, a victim of the opposite opposing gang is killed. And so, Judge, this jury should have a real, true, accurate picture of the very gang war that is going on. And these incidents also, even though they exceed the time frame, I understand what they're saying about Richardson and Hayes. the particular of that gang war, the escalation of violence, but it was 6 shootings that occurred back and forth, happened in a very short period of time. It's different in this case, but the incidences that we have selected are relevant to this case. And some of the relevance doesn't even have to do with any of them. It has to do with the victim and as a consequence with all of them, because the victim in this case, the motive for, and obviously one of the rap videos that we're going to introduce and the motive for why they did not like him and were very upset and angry enough to kill him is his drill rap videos. And certainly that also goes to our gang experts' testimony. They do have specialized knowledge. This is something that they all have years of experience in this gang unit where they are monitoring this activity on social media. And it's not hearsay. They are visually monitoring it and they see a death happen. And then within 2 or 3 days, sometimes within the very next day, there is a video that is posted detailing and ditching the person who was just killed.
Well,
All of that.
desecrating someone's gravesite is pretty provocative behavior.
Yes, Judge. All of that is part of this gang war back and forth. And the jury needs to have an accurate view. And some of this is highly prejudicial towards the victim because the victim is out there doing the same thing, which makes him a target. And he is dishing and disrespecting the close members, people that we can connect to them, either through their wearing necklaces. They have posted their own videos, Judge. All of that is relevant to this case and is inextricably intertwined and shows why he was targeted and why he was killed. And Judge, when you talk about the hearsay, that is why we have listed either a first responder or the detective. Detective Nieder actually responded to some of those incidents. So we are not going to call 6 witnesses, but certainly the ones that he did not respond to, we have just listed a first responder, or we have listed the detective who actually went on scene and can say, on this day I responded, this person was killed and his name. And then we will go to our detective to say that that is a confirmed member of 1200, or that is a confirmed member of 6 Block or Bully Gang, which is a subset of 6 Block. So this by no means is going to be a feature of the case. And all of these detectives, even within the depositions, were honest and said they didn't know that that was an unsolved case. But certainly after a case where a victim is identified as a gang member and the opposing group then posts a video claiming credit, making fun of that victim's death the very next week or within a short time period, certainly that is a specialized knowledge, and it goes to the very heart of this case and the very motive why our victim was killed. And the probative value of motive, wanting to kill the victim, has a high value, and it is not going to ever be outweighed by the prejudicial nature. And that is what Harris and Richardson really explain when it let in 6 other shootings into a case, because it gave the jury an accurate depiction of the war, the escalation of this gang war, which led to those 3 people being shot and a child being killed. And so, Judge, that is what we have here. The prejudicial nature is not so significant. Some of these deaths are from our victim side killing the other side. The ones that are targeted, they are not charged with, and none of the detectives said, with the exception of the attempted murder. And we know we're not going to elicit what their personal opinion may be, but certainly there is going to be physical evidence that ties this as part of the conspiracy, that they tried to kill him before and they weren't able to do it. So certainly all of those incidents, even though we go outside of that time period in Richardson and Hayes, are still relevant. They're inextricably intertwined. And those specific cases are tied to our victim and the defendants in this case as being relevant. And again, highlight the animosity between these 2 groups. They're making fun of people that are killed back and forth. Some of these shootings within the very next day, including the attempted murder of Charles Jones, was done the very next day after members of the opposing side, one of their members, was shot. And so that is the state's argument that this is all relevant. It is not going to be a feature of the case, but it goes to the very heart of all of this group's motive, to kill Charles Jones, the victim in this case.
Okay, so in the Hayes case, the court stated as follows, and get the page number. At page 1130 of that opinion, in establishing its case, the state is entitled to present evidence which paints an accurate picture of the events surrounding the crime charged, but cannot make the evidence of other crimes the feature of the trial or introduce evidence solely for the purpose of showing bad character or propensity. Collateral crime evidence, regardless of its status as similar or dissimilar fact evidence, is admissible if it is inextricably intertwined with the charged crime. Collateral crime evidence is inextricably intertwined if it is necessary to 1, adequately describe the deed, 2, provide an intelligent account of the crimes charged, 3, establish the entire context out of which the charged crimes arose, or 4, adequately describe the events leading up to the charged crimes. Additionally, evidence is admissible if the prior incidents are relevant to several material issues, including motive, intent, and identity. So based upon the facts and the motions and the arguments of counsel, I am going to find that the 6 identified incidents in the state's motion in limine are inextricably intertwined, and they are relevant to motive, intent, and identity. Okay, so those, just as a threshold, those 6 incidents are admissible in this case. All right, I'm going to take a recess. And so actually, before I do that, so as it relates to the state's motion in limine regarding those 6 incidents, I'm going to grant it. Let me just take a look here. I'm going to grant the motion, but I'm going to reserve ruling regarding the introduction of any videos, any rap videos that the state seeks to introduce. And once the state does their evidence list, as far as what they're actually going to attempt to introduce, then if there are further objections as to any individual videos, defense can renew their objection and I'll rule. Okay. All right. So as to Isaiah Chance's motion to exclude inextricably intertwined evidence at trial, that motion is denied. However, defense, as I indicated, can raise contemporaneous objections to any individual items of evidence. And with regards to Sean Gathwright's motion in limine to exclude collateral evidence, that is denied. However, again, defense has the ability.
Well, and can I add, because I actually specifically addressed those other 2 instances, the state is not seeking to evict, so could that be?
Yes, it's denied as to the 6 incidents that are in the state's motion that I've articulated here today. It would be granted to any other incidents that are not part of the 6. And that goes as to all defendants. Okay, so we're just talking, so it's denied in part and granted in part. Thank you for that clarification, Mr. Wise. And then as to Rashad Murphy's second motion in limine, there were a number of items, Mr. Gonzalez, that you raised. At this point, it's denied in part only as to the 6 previous incidents that I articulated here today. Okay. All right, we'll take a break and I'll be back at 10:50.
Court's in recess.
Okay, so y'all, even though she's taking a break, y'all know we can see past this part, but just to kind of give you an update, we heard a lot of things that were denied. They're trying to get these videos in regards to this digital evidence. So some of it was denied and some of it was honored in regards to it. in regards to that information coming in. So, of course, the videos, I think we even saw a video on Alicia Andrews' case. So I wouldn't be surprised if we see that, see those again, because they do all the self-snitching in all these videos. Welcome to all the new members, everybody that's tapping in with us today as we look at the last week coming closer to trial. Don't forget, we do have our update on our Alicia Andrews portion. Hi, what's up? Our Alicia Andrews portion that we're going to discuss a little bit later. Because boy, oh boy, they are fighting. And I do mean they fighting. And I think they have a chance. And I'll say that for later at the end. And hopefully the documents, because she did have a court hearing today. So hopefully we'll be able to go over those documents later if they upload them. But let me see. Let's get us past this part. No. Oh, we're good. It looked like they got us already skipping. So that's great. Okay. So I'm going to take us back into court. Thank you guys for hanging out with us. I know you can be anywhere, but you decided to be here, and we appreciate you. Don't forget to answer the poll question in regards to, do you think these cases should be separated? Does it really even matter? I mean, unless some evidence is so overwhelming. Now, the only thing that I can see right here is if we talk about Sean Gaffright, because he is not a quote unquote a known, gang member. They did not have him on any lists or anything like that. So he is the only person I could think of in this case that I would want to separate from him, from everybody else. But it's just a small portion. I mean, remember, Sean Gaffright is our weapons man. So he supplied all the weapons. But let's get in here and let's see what we have for this afternoon in regards to the rest of the motions and everything they're going to be hearing.
26 at 9 a.m.
Okay. So I am currently available on the 30th of March and the 31st. Also Monday the 6th, but we pick our jury the 8th. So you guys, I'm sure will be busy getting ready. So you tell me what works best as far as the last round of
y'all hear that?
motion
Jury
hearings.
selection is going to start on April the 8th.
31st, I would think.
I don't want to see 4 separate trials. I want them to do this all together, one for all together, one for all.
All right. How does that work for everybody? Okay. So can I say 10 a.m.?
Is that March 30th, the court said?
March 31st.
Yes, Judge.
Okay. Mr. Sonardi, Mr. Wise, Mr. Petratus, at work?
Yes.
Okay. All right, March 31st at 10 a.m. We'll call it a status and final motion hearings. And I think my JA is working on the seating chart for jury selection for the 150 where they will be. So I will give that to you all when I see you on the 31st. Okay.
Okay, so I do have one question. When we was watching YNW Melly and YNW Bortland, and we was watching their case, and during these proceedings and before hearings, my guy Bortland, he had on some Jordans. I'm assuming down here in Hillsborough County, they don't allow them to wear J's on their feet. Why is that? Like, what's up with that? I'm assuming it's different in different places in Florida. But why they can't get J's on their feet, or is their commissary not being lit up like they thought it once would? And when you think about all this stuff, I want y'all to know, who is the only person that did not have a public defender? I'm pretty sure all of these attorneys up here are public defenders. Alicia is the only one that didn't have a public defender because she wasn't about that life. I don't believe she was about that life at all. She was just with her boyfriend. It was just her boyfriend, and she done got caught up. And besides, I think her parents had some money. But okay, here we go.
All right, okay, moving on to Defendant Rashad Murphy's fourth motion in limine, opinion identification testimony, and I think Mr. Sonardi filed a similar motion for Davion Murphy, defendant's motion in limine to exclude law enforcement from interpreting or narrating video surveillance.
We did that, Judge.
Pardon me?
We did that, didn't we?
Did,
No.
no,
I don't think so.
no.
Your Honor, Mr. Murphy's fourth motion in limine relates to opinion identification testimony. Again, we've been having a lot of discussion, a lot of argument with these types of areas of evidence. The state intends to introduce a large volume of digital media during the trial, surveillance videos of the shooting at various locations, music videos, as the court's aware, some Airbnb footage, surveillance footage from different businesses, surveillance footage from different jurisdictions, Jacksonville, Polk County, Hillsborough County. And again, the state is going to rely on law enforcement, on the detectives to identify Mr. Murphy in any of those recordings in which they believe he's located. In general, Judge, and pursuant to Bentley versus State, a witness can only testify to the identification of someone depicted on social media when the witness is in a better position than the jury to do so. And obviously, age-old proposition, and I cite Bentley at 286 Southern 3rd 912, second district case. And it would suggest that when evidence is such that the witness is in no better position than the jurors to make an identification, then that witness's opinion is inadmissible because it invades the province of the jury. Moreover, in particular in this case, is that law enforcement officers are not permitted to offer an opinion identifying a defendant in digital media unless that witness, that officer was an eyewitness, had a special familiarity with the defendant, or is otherwise qualified as an expert in identification. And that's citing Proctor and Charles, which are cited in the motion. It's my belief, Judge, that no member of law enforcement in this particular case, based on depositions that have been taken and evidence that's been elicited in motions, is in any better position than a juror to make an identification in this particular case. In Mr. Murphy's circumstance, I anticipate that, number one, there will be rap videos that the state has still shots of where they will attempt to identify Mr. Murphy in them. And my position would be the jury can look at Mr. Murphy and look at the still shot and determine whether or not that is Mr. Murphy or not. Certainly, law enforcement, all of them, have had a relatively minimal amount of time over even the time that they've been in the gang units, based on testimony, to have interaction with Mr. Murphy and to see Mr. Murphy on multiple occasions. And so with that in mind, as it relates to that particular identification, I believe the only other thing that, other than people testifying, I've seen Mr. Murphy, but I can't tell you where, and I can't tell you when, and I can't tell you with who, would be that there is Jacksonville footage where it is alleged that Mr. Murphy is getting out of a vehicle, an Uber vehicle, and there is surveillance video from that house that would be admitted for the purposes of identifying Mr. Murphy. in that same circumstance, and that based on that same premise and the law surrounding it, my suggestion to the court is that a police officer can't say, look, there's Mr. Gathright, he's getting out of that car. There's Mr. Murphy, he's getting out of that side. There's Miss Andrews. Court, I believe it was probably introduced in the Andrews case. There's Miss Andrews, she's getting out of that car. I believe that the jury can make that determination. It's their province, and no law enforcement detective is in any better situation to provide and authenticate that evidence. So with that in mind, Judge, I'm asking that you prohibit identifications from detectives as it relates to Mr. Murphy and any digital media that is alleged that he is in.
Okay, very good. So who's arguing this motion for the state?
Judge, I am.
Well, don't, and do you concede that Bentley versus State at 286 7th 3rd 912, which is a second DCA opinion from 2019, that's basically what the law says, right? That in
Judge,
general, a witness may testify as to the identification of persons depicted in photographs or on video when the witness is in a better position than the jurors to make that identification.
Judge, I do agree with that. Judge, generally, I also am going to provide the court with some case law as well, and that's Johnson v. Florida, as well as Kopp v. Florida. And in Johnson v. Florida, there was an officer who was allowed to identify a video and still photographs extracted from a video because they were in a better position than the jury. In particular, it was not from prior, but for instance, if the officer is aware of the defendant's appearance, that how they look at the time of the offense, and if it has changed. So for instance, Mr. Chance, the defendant over there, his hairstyle is much different and shorter than it was at the time when this offense was committed, where he is being viewed on a Ring camera. And so if you look at Johnson v. Florida, it's a 4th District court case where in this particular case, an officer is in a better position to be able to identify the defendant based on that scenario, how they looked at the time of, and it is not prejudicial because it was limited to that officer's familiarity with the defendant at the time of the crime. So it doesn't go to any sort of prejudicial nature of any sort of prior contact that they had with the defendant. And again, I also provided the court with Kopp v. Florida, and this is where a security guard who never identified himself as a security guard, who had a bunch of numerous contacts with the defendant in that case, and he had watched the video several times and was very familiar. But in that case, it was a grainy video, and he was able to testify and identify, but not say that he was a law enforcement officer. So, Judge, the two cases I've presented to you, and in this case, when we're talking about the video of the scene, there are 3 individuals that are masked and armed. I do not and will not be presenting any sort of evidence from any of the officers in this case as to who those individuals are. However, the main case detective in this case, Detective Ramos, when he is questioned as to or cross-examined by defense if any door is open as to how many people are involved in this crime and if certain builds and stuff of that nature go to how he put this case together. Certainly that isn't a statement of identification, but that goes towards his investigation and him looking at builds and stuff of that nature to circumstantially be able to put forth that case. But as it goes to the Ring videos, and again, defense attorney, Mr. Rashad Murphy, he is not captured on that Ring video. Some of the other defendants are, and some of their appearances have changed. I believe that Johnson v. Florida, as well as Kopp v. Florida, give us the right to be able to have law enforcement. For instance, Mr. Isaiah Chance, the case detective, met with him on 3 occasions. One of those meetings that he met with him was for several hours. And because his appearance has changed, and if his appearance is changed from when the crime occurred, that would be appropriate for us to do.
Okay.
And Judge, as far as the videos and the wrap, again, we do plan on, based on expert testimony, I think, which is separate and different based on their part of their job to identify known gang members and studying of videos. And in those videos, there is significant change in appearance as to weight, as to hairstyle. The one that particularly that Mr. Gonzalez is talking about, it was a much older video, so we would want to lay the foundation of exactly when that video was first presented. The defendant had much longer hair and was much thinner at the time of. So we do, again, plan to present expert testimony in that area based on what they were supposed to do and monitor videos, and were tasked with identifying all the individuals within that video based on their expertise. Obviously, it would go to the jury, the ultimate question, whether or not they truly believe that person is in the video.
Sure, although I haven't.
Hold on, wait, what?
Yes, I apologize. When I said Johnson v. Florida, 93 Southern 3rd, 1066, and common spelling John, and then Kopp v. Florida, KOPP 314 Southern 3rd, 451.
Okay, hold on. Any just
Judge, although I haven't had a chance to read Johnson very closely at this particular time, I would note that I don't believe expert testimony changes the foundation of this case law when they're talking about detectives versus non-detectives, and it's not distinguishing as to whether or not a jury is in as equally as a good position to make an identification. As it relates to Kopp, just looking at it very quickly, I would suggest to the court that it is distinguishable because, as Ms. Doherty said, the videotape is very grainy. It did not provide clear images, and zooming it only worsened it. And therefore, because of that, the witness in that case was allowed to make that identification. And based on what I certainly have seen, I can only tell the court that that is not the circumstance, either in the still photographs that I'm aware of or the video when it's run in real time. So to the extent that I believe Kopp is distinguishable, I believe the court still should rule in the same manner.
okay, Mr. Sonardi, any further
Nick
argument?
Sonardi on behalf of Davion Murphy, Judge. Yeah, we have filed a similar motion to preclude, obviously, any of the state's witnesses, be it experts or anyone else, from in any way narrating the videos. That is, includes surveillance videos and any of the rap videos. We would indicate that that is the province of the jury to determine what, if anything, those videos depict or identify. And again, we dovetailing on the motions of Mr. Rashad Murphy.
Okay. Okay, so the state,
I'm sorry,
Yeah.
I didn't know that we were talking about the motion to narrate. Can I just briefly respond to that?
that's fine. That's fine. I'm going to reserve ruling on that part anyway, but yeah, go ahead.
Judge, with regards to, we're not obviously not going to put up any of the witnesses to narrate. However, the surveillance videos, I do have the right to question on direct examination any sort of areas that are important to the detective can assist in explaining that, like where the cameras are set up,
Sure.
and any sort of questions that go towards his investigation. As far as the rap videos, we're not going to narrate the rap videos either. But again, questions are going to be put towards the gang expert as to some of the significance of what is happening in that video and how it is pertinent and relevant to this case.
Okay.
Judge, and one other thing, since I read Johnson, and I apologize, one of the main reasons the court allowed the identification in that video is that the defendant, after the commission of the crime, had bleached his skin. And certainly that turned out to be a very significant change in his appearance that would have given rise to the fact that the detective had spent hours and hours and hours with him prior to the commission, post-commission of crime, that he could make that distinguishing identification.
Okay. Okay, so as to defendant Rashad Murphy's fourth motion in limine regarding opinion identification testimony, it is granted, as that is the controlling law pursuant to Bentley v. State, unless there is an exception, and specifically as noted, exceptions would be if the quality of the video is poor, or if in some respect the defendant had changed their appearance after the offense was committed. Those would be the types of exceptions. So the state just needs to be prepared to articulate what would be the exception to Bentley that would allow the law enforcement officer to identify anyone in the video.
Yes, Your Honor.
Okay, and then with regards to defendant Davion Murphy's motion in limine to exclude law enforcement from interpreting or narrating video surveillance. As far as identity, it's granted, which would be subparagraph A. That's granted, again, unless there's an exception, and if the state's going to seek to have the witness, the law enforcement witness, issue an opinion as to identity, you just need to be prepared in advance to tell me what the exception is. As to the narration, subparagraphs B and C, I'm going to reserve ruling on those. I just need to hear the evidence as it comes in, and you just need to make a contemporaneous objection.
And Judge, that would relate to all defendants?
Correct. That applies to all defendants. Okay? All right. Thank you. Oh, do me a favor. Attach these two to the back. Okay, thank you. Okay, all right, let's see here. I have defendant Rashad Murphy's fifth motion in limine regarding irrelevant evidence. And okay, go ahead.
Judge, understanding the court has made some rulings already this morning, whether they be reservations of rulings or rulings. Again, there's some dovetail in this motion. It's several different categories of motions, and without being overbearing, I just want to make sure that the ones that have been reserved on or ruled on, the court will identify it for me one more time, and of course those that need to be ruled on, you do so. The first category, Judge, is NIBIN evidence. There are TPD analyst Sarah Price conducted NIBIN analysis of 9mm casings found at the homicide scene. She reported that those.
I'm going to this up a little bit.
Okay.
I'm agreeing to the NIBINs, as previously stated. And I think A through E are ones that I've already stated that we are not going to go through,
Okay.
because that's not the attempted murder of Charles Jones.
Got it.
All right, let me just take a look. When you say A through E, are you referring to what?
So on page 1 of his motion, he lists, I think this is what he's talking about.
Okay, yeah,
There's A through E.
okay, and you're agreeing those are not covered.
Yes.
Okay, so it's granted as to paragraph 1, items A through E on defendant's fifth motion in limine. Okay?
Judge, next items, and before I go off the rails, casings seized from Gathwright's vehicle. I believe we've discussed those already earlier this morning, did we not?
We did, except one of the casings goes to the attempted murder of Charles Jones. I'm not agreeing to that one.
And which one is that one? Is it A or B?
Judge, I'm trying to look at,
I think B is the one you're referring to.
yes.
It is.
It's B.
So you agree to A and C, correct?
Yes.
Okay, so it's granted under paragraph 5, A and C of defendant's Rashad Murphy's fifth motion in limine. Those are granted pursuant to stipulation of the state. And then is there any further argument as to item B?
Only, Judge, that it has been the fodder of argument in other motions as it relates to A, inextricably intertwined evidence, which the court has ruled upon, but also as it would relate to the court's inquiry, which we'll probably get to at the end, as to evidence that is admissible potentially to a defendant or one defendant and not admissible to another. And my argument later will be that the casings found and the identification to the Charles Jones attempt on October 7 would not be admissible as it relates to Mr. Murphy.
Okay,
And I assume we're going to talk about that later.
okay. All right, well, as to that specific item of evidence, the motion in limine will be denied. Okay.
Third, Judge, would be firearm-related evidence. The first would be Mr. Gathwright's vehicle search. I believe the state indicated that, and please correct me, I'm wrong, that those items found in Mr. Gathwright's vehicle you're not going to seek to admit those? Okay, Judge, as the court can see in paragraph 10, on June 26th, as a result of Mr. Gathwright's vehicle, this is another circumstance where we would ultimately later be arguing, pursuant to the court's request, that these items that are found in Mr. Gathwright's vehicle, all of which do not have any direct correlation to the instant murder, first and foremost, and secondly, certainly don't have any relationship or relevance as it relates to Mr. Murphy, should not be admitted. And again, would dovetail into one of the reasons for severance, that this evidence is not relevant to Mr. Murphy. It occurs on June 26th. Obviously, one of the tenets is what happens outside of the conspiratorial temporal time frame, and dovetails into the question that the court asked about co-conspirator statements versus evidence that that is found, let's say, in the possession of a co-conspirator. And that's dealt with in my supplemental filing that the court, I'm sure, has read already, but I'll take a short amount of time when it's appropriate to argue that. So that is the next category of evidence that I believe should not be admitted and is irrelevant.
Okay, state what's your response. Are you seeking to admit all of these items, 10A through R?
Judge, yes, we are.
And they're not connected to the charged offense in any respect.
Yes, they are, Judge.
Okay, well, okay, Mr. Gonzalez, are you done?
I am.
Okay, so Ms. Doherty, why is this relevant?
Judge, first of all, he is a principal, and if you look at the box of the new Straight Talk prepaid phone that is in Gathwright's vehicle, as well as the prepaid car, and there was a receipt saying that he purchased it on June 6th. We also have evidence showing that he also changed his iCloud account and opened a new iCloud account on that day. Also, within the same vehicle is a piece of paper with several phone numbers. So immediately 2 days after this crime, Mr. Gathwright gets a new phone. His phone that was utilized in the crime, where he's communicating with the second vehicle, is never located. We can show that he purchased it 2 days afterwards. The note that is found with all the phone numbers so that he can program his new phone include the defendant, Rashad Murphy's phone number. The shared phone number that he has with Charmaine Steiger is specifically written out. And it doesn't say Rashad Murphy as the person belonging to that number. It says GH. Again, his nickname is Ghost. So there's a direct link to the co-defendant. Another number on there is G. The nickname for Isaiah Chance is Gutta-Zay or Gutta-Man. That number matches his number specifically. So these are physical items of evidence, and he is a principal. All of the defendants are principals, and so these relevant items of evidence that pertain to the guilt of one defendant certainly is admissible if we prove the other defendants, all of the co-defendants, are principals to the crime, and we certainly will prove that they are all principals to the first-degree murder, as well as some of them are principals to the attempted murder of the three other individuals. Judge, if we go back to all of these other items, they are relevant to what we know about the shooting. We have video evidence of how this crime occurred, which 2 AR-style rifles were used, and 1 9mm Glock that had a switch on it. And so all of these items that they have listed on there are relevant because they are either fireable in the AR rifles or attachments that could go to the AR rifles that were shown to be used in this crime that was captured on video. And in particular, the Max Tech 9mm ammunition. They say 2 boxes of unused 9mm Lugo. That actually there was a brand, and that was a Max Tech brand of ammunition, which was the exact brand of ammunition of the shell casings left at our scene. So certainly those are very relevant to the crime. And again, principals, they are responsible and are put in the same shoes of each person that we have proven committed and participated in this crime if they did something to assist. So all of these evidence that are listed, that we did not put in everything that was found in the car, but just the items that we believe are relevant to the actual firearms that were used in this particular case. And Your Honor, may I have one moment?
Yes.
And Judge, just again, the other connection to this particular, all of these items being relevant to this case, again, it's 2 days after our crime was committed. We know and we have evidence that Mr. Gathright was in the suspect vehicle, the Chevy Impala, which he drove and left purposely at his grandmother's house in Polk County. And he was seen by his grandmother moving several items from the Impala into this vehicle, and that is why that vehicle was targeted. So obviously, again, another connection to this crime. We have items of evidence that are significant and relevant to how this homicide and attempted homicide occurred here in Tampa.
All right.
Judge, I would only respond that, again, I don't believe the fact that because the state is setting forth a theory of principles, and because they're setting forth that it's their theory of a prosecution, that this particular phone is a phone that was purchased by Mr. Gathright, not by Mr. Murphy, in order to replace potentially, as a theory of prosecution, a phone that he no longer wanted anybody to have, doesn't get it any closer to being admissible against Mr. Murphy, nor do I believe, and again, reserving argument for the court's question as to evidence as opposed to statements as it relates to co-conspirators. The fact that none of these items have a direct relationship to the crime at hand certainly is extremely prejudicial, and not the kind of prejudicial evidence I would suggest to the court that happens just in cases in general. It far is outweighed by its prejudicial value, and that is especially not as much to Mr. Gathright, but as it relates to Mr. Murphy and, quite frankly, any other defendant.
Okay.
Next, Judge. Oh, I'm sorry.
Okay, so I'm going to deny the motion as to paragraph 10, items A through R. All right, next up would be the paragraph 12, the items from the residential search of Mr. Gathwright's residence.
Yes, Judge. On the 27th, a day later, Mr. Gathwright's home was searched. There are 2 AR rifles equipped with black mesh brass catchers and 2 spent 9mm. The 9mm were recovered. Oh, they matched casings recovered from the homicide scene, but in a kind of a unique situation, the court might remember, they could not have been fired at the homicide scene because there were the requisite amount of casings found on the 9mm that would have filled the firearm. I'm not a firearm expert or even eloquent as it relates to firearms, but the point being is that Detective Ramos subsequently testified, look, we now know that what was found in Mr. Gathwright's home could not have been fired that night, but certainly that doesn't preclude the fact that there is a match between those casings and this casing. So maybe it was fired from the same firearm at another time. So my argument essentially is the same as it relates to the admissibility of this evidence and its relevance and relationship to Mr. Murphy, and albeit something that may be considered relevant or admissible as to Mr. Gathright, not so as it relates to Mr. Murphy. Number one, again, far outside the conspiratorial time frame, and secondly, doesn't have any direct relationship to Mr. Murphy.
Okay. All right, state, why are you seeking to admit these from Mr. Gathwright's home? Items A and B.
Judge, I'll speak if I could, Your Honor. May I have a voting?
Sure.
I'll speak to the relevance of the firearm evidence, and maybe Ms. Doherty can speak to the relevance to Mr. Murphy specifically. So the two shell casings are 9mm shell casings. Just like the ammunition found in Mr. Gathwright's vehicle, they are Max Tech brand 9mm shell casings. 31 shell casings were found at the scene, 9mm shell casings. All Max Tech brand ammunition. So this is the same brand ammunition. If you recall, in the Andrews case, Bernard De Jesus, who was on scene post-fact, did some interviews, testified, and a predicate was laid to his knowledge and expertise in firearms. And he testified, based on his knowledge of Glock firearms, that the, quote, stick magazine, which is an extended magazine that is utilized in Glock firearms, holds 33 rounds. 31 rounds were found at the scene. These are the other two, it is the state's theory, additional rounds that, in his opinion, during the trial must have fell into the brass catchers as they were being ejected from the pistol, or may have fallen into the brass catcher on one of the other shooter's rifles that was nearby, because the brass was ejecting in the videos towards the direction of the rifle shooters. So that is the relevance, physical relevance of the evidence. And I can let Ms. Doherty speak to the relevance to Mr. Murphy, Rashad Murphy.
And Judge, again, he is a principal to the crime, and all of the physical evidence that are related to the crime would be admissible in his trial as well. Even though it's found in another co-defendant's house, it is a part that has ballistically been connected to the homicide. The two AR rifles both match the appearance that are the two AR rifles that are used in this case. There isn't a ballistic or forensic link because none of those shell casings were left at the scene. So we could not do a comparison based on that. But we know that they had mesh brass catchers, which we can definitely see that in the video. So it is definitely very relevant, very probative, and the defendant is charged as a principal, and that evidence certainly would be admissible in his case as well.
Okay. All right. Anything
Judge,
further?
before I go on, just two particular statements with regard to that. Number one, the brand there's nothing unique about this brand of ammunition. It is a common brand of ammunition that it's sold regularly in virtually every gun shop in America, and has no direct relationship to this homicide other than the fact that the brands are similar. Secondly, the appearance alone of those AKs should not be the basis for admission simply without any type of forensic connection whatsoever. It certainly its prejudicial value outweighs its probative effect, and that's what I would say with regard to those items in Mr. Gathwright's residential search of 627.
Okay. I'm going to deny the motion as to items 12A and B. Their probative value outweighs any prejudicial effect. Okay. Moving on to the items recovered from the search of Isaiah Chance's home.
Judge, on the 27th, the same day, soon thereafter or simultaneous with Mr. Gathwright's residential search, Mr. Chance's residence was searched. There was a Glock 9mm with an extended magazine, some ammunition, Generation 5 Glock ammunition. notes that detail how to utilize, I guess, a Glock switch. None of the evidence seized from Mr. Chance's residence, to my knowledge, had any evidentiary connection to the charged offense or to Mr. Murphy. And for those reasons, Judge, and essentially with regard to the same argument, except for the fact in this particular case, I think it's one step removed from items found in Mr. Gathwright's possession, home, or car, and that is that these items have no direct evidentiary connection.
Okay, state, why are these admissible as being relevant?
Judge, I'm agreeing to the Glock 9mm pistol with extended magazine and the box that it belongs to, because we did compare it to our shell casings and it was determined not to be the Glock that we're looking for or that was used or licensed in this case. I am going to object to the notes detailing the Glock switches in the notebook, because in this particular case, one of the assailants was using a Glock that had a switch on it. So I do think that that is relevant to this case. And another video, a ring video where they are loading up right before they come to Tampa on June 22nd of 2024. Isaiah Chance can be seen to have in his possession what appears to be a firearm with a switch on it. So it is relevant to the case, especially when we have video footage at the scene, and based on the scene as well as the projectiles that were left behind, we know that we are dealing with a Glock switch firearm.
And when it says notes detailing Glock switches in a notebook, what is it?
Judge, there's so much evidence of this case. I would like the opportunity. I don't want
Are
to
they
mislead
handwritten?
you.
Okay, you just don't know.
Judge, I don't know. I can't remember specifically, but I can't. It's been a while since the last trial.
Okay.
It seems like it may have been something printed off the internet that showed the dimensions of the box switch and how to install it. That's my memory, but I would like to check.
Okay, I'm going to reserve ruling on that one, which is C. And what about a box to a Generation 5?
Granted, Judge, the state stipulated that.
You
Yeah,
stipulate.
Judge, we know that the Glock
Okay.
and the particular one that was located is not
Okay.
the gun. Yes.
So paragraph 14, items A and B, the motion's granted. Item 14C, I'm going to reserve ruling just to give the state a chance to clarify what exactly it is, and then we'll go from there, what the notes are. Okay, moving on to the bully down poster.
Yes, Judge. During the course of the search of Mr. Chance's room or a house, in his room, there was a homemade poster that signified the phrase bully down. Bully down, according to testimony by the detectives, is again, gaining that knowledge through the same manner in which they gain the majority, if not all, of their information in their day-to-day activities, is allegedly a subset. Bully down is a subset group of the gang. And whether they're suggesting that Mr. Chance
Subset of 6 Block.
So bully gang is a subset of 6 Block, potentially, allegedly adversary to Mr. Chance. And these are bully down. And the suggestion, and I assume the testimony is going to be, that signifies a diss, or that signifies that bully goes down, something of that nature. Again, they're saying it's in direct disrespect aimed at Foolio or at Charles Jones. Again, under most of the same theories I've been arguing, that Mr. Murphy has no connection. There's been nothing to suggest that Mr. Murphy had anything to do with making that poster, with aligning with that particular mentality or statement if it's just a creative statement based on the word bully down, and that although the state alleges a conspiracy, again, we're back to the same conspiratorial window, and whether or not items and acts are different than conspiratorial statements. And so all of those circumstances combined would suggest, and of course, I don't need to tell the court as I go along through all these things, the admission of those things are part and parcel of the reason that I believe that severances should be granted. But I don't believe that they are relevant and admissible as to Mr. Murphy.
Okay, state, what's your response? Why is this admissible?
Judge, it is a poster that they find, which the expertise from the gang will show that this particular, it's kind of a thumbs down poster in reference to the bully gang, the subset of 6 block. Not only do we have the expert testimony as to what that means, we also have the interview with Isaiah Chance where Detective Ramos specifically asked him about that sign. And there is some acknowledgement on his part because he starts kind of laughing, acknowledging that they had that. As well as particularly with Rashad Murphy and those videos, we had taken still shots from the videos that certify him as a gang member. He is making that same bully down symbol, the thumbs down kind of symbol in reference to that particular gang. So there is all kinds of connection, Judge, as to the relevance of that located again in a co-defendant and principal to this case.
And is it your position that the evidence of this poster would be admissible against all of the defendants?
Yes, Your Honor.
Okay. All right, I'm gonna deny the motion. Next step would be the Walmart cell phone purchase.
Yes, Judge. In the 24 hours before Mr. Jones's murder, the defendant purchases several items on video from a Jacksonville Walmart, including a prepaid cell phone. Initially, Detective Ramos testified that he believed that this defendant purchased that phone in order to use it during the course of the homicide. Later, however, he confirmed and testified that the purchase of that phone was entirely unrelated to what he originally thought. The phone itself and the purchase of the phone has no relevance to the charged offense, especially as it relates to Detective Ramos's testimony. And the admission of the phone would create a risk that would invite the jury to draw some type of unproven and unsupported evidentiary link between Mr. Murphy and Mr. Gathright simply because of the nature of 2 straight talk phones being purchased by 2 individuals who are alleged to be principals to this particular crime. And it would infer a propensity unrelated to any materiality that this phone has, especially after further explained by Detective Ramos under oath.
Okay, state, why?
Judge, I'm in agreement with that. We, although we are still going to present evidence of Walmart and what the defendant was wearing. And
Right.
there is a photograph that shows the phone that we do not intend to introduce based on or mention the reason of the phone, but the reason that it is necessary is because there is a black boot that is definitely identifiable in that photograph, as well as the rest of his clothing is pertinent to this case and what he's wearing. But we're not going to go into the specifics of purchasing that cell phone or what it was used for. I think that based on their investigation, they did discern and learn that it was going to be smuggled into a jail, and we're not going to go there.
Okay, so it's granted.
Judge, lastly, there are still images on Mr. Murphy's phone. The court is going to do a written order with regard to the motion to suppress the cell phone. If that would happen, this would be moot. To the extent that the court denies that motion, a full extraction of Mr. Murphy's phone was not possible because law enforcement damaged the phone without intent, but nonetheless damaged the phone while it was in their custody. And they were only able to get a manual review and extraction from that phone. The screenshots, there were screenshots that were extracted from that phone, 4 of them. Number one, on June 19th, at 1:29 p.m. Eastern, there was a screenshot of a homicide scene that a Young and Ace song was tagged. Again, without getting into the many number of different ways in which that image in of itself, and then the song in and of itself could have gotten on that phone, that's a story for potentially another day. But it's that image, number one. Number two, a day later on the 20th at 11:02 p.m., there's a photo of 2 rifles that were documented. They are similar to those used in the homicide, but they are not tied to the homicide in any way, shape, or form other than their appearance. June 22nd at 3:09 a.m., there's a photo of a bag, and I assume, again, this is a bag showing a Straight Talk Wireless phone, the phone charger, the packs of cigarettes. These are things that were purchased at Walmart. If the state is on the same vein, I suspect they may say, okay, we're not going to use that. But the photo itself, because of the boots that are being worn in the black pants, certainly is relevant. I'll let them argue as to that. On the 22nd, also at 7:26 p.m., there's a screenshot of a text message conveying instructions on how to enter the prison and retrieve a Walmart bag. I would suggest, for the same legal basis that I have argued previously, that these photos, screenshots, pictures are inadmissible. There's no evidence to establish the identity of the people who originally posted those images to social media. And even if authenticity could be determined, the images that are unrelated to this particular homicide have no relevance. I go into a little bit further argument as it relates to the tagging aspect, and essentially the tagging of that song, although we can't suggest that Mr. Murphy had anything to do with that. In addition to Young and Ace being a gang member pursuant to testimony from gang detectives, he also is a labeled artist that gets millions and millions and millions of views with regard to all of his different songs. And they are not all drill videos, and they are not all videos that troll or disrespect other people. It is an entire litany of a music catalog. Again, Judge, the state cannot link those firearms to Mr. Murphy in any respect, other than the fact that that picture was sent to him and was on his phone. And in that light, Judge, I would ask the court to prohibit their admission.
Okay, state, are you seeking to admit paragraph 26, items A through D? And if so, why?
Yes, Judge. 26A, the screenshot, it was posted, this is a shared phone to Rashad Murphy and Charmaine Steiger. This is a phone that Ms. Steiger originally said shared, and they equally used, and was found in the defendant's possession. Later, she has recanted and said that it was her phone solely. So obviously, proving attribution is also going to be the state's burden as to who actually uses this phone. We would be willing, there is a Jacksonville homicide scene that is part of it. We would be willing to redact that out. What we are interested in here and what is relevant to this particular case is that on that day, he is tagging Young and Ace's song. And that was captured in a screenshot. And obviously, Young and Ace is the member of ATK. He's one of the founding members, and predominantly in some of these videos that are directly relevant to this case, including videos that were posted after the victim was dead, detailing his death, that were posted a few days after the homicide. As to the photos of the two rifles, they are sent June 20th of 2024 is the timestamp that is in the defendant's shared phone. Again, these two phones match the appearance of the rifles that are used in this case. And there is another connection to Sean Gathright. That same photo is found in Sean Gathright's phone. So that is very relevant, highly probative, and outweighs any prejudice significantly. On June 22nd, that photo, again, we're not interested in the phones and anything else in it, but that is the one photo that we have. It's not really discernible in the video footage from the Walmart of the type of boots that he's wearing, and he's wearing black combat boots. That and everything else that he's wearing matches one of the armed mass shooters in our case, and this is a day before the homicide occurs. June 22nd, the screenshot of text messages with instructions to prison security gates, we are agreeing not to go into that.
Okay,
Judge, I only have one short
sure.
2-second rebuttal, and that would be as it relates to item A, Judge.
What was the Young and Aces song that was tagged?
I do not recall. I don't believe it's one of the ones that the state's going to be entering. That would be number one. It is not one of those songs. And second of all, Judge, they said the defendant tagged this song. They don't know that, and I could be wrong. My understanding is anyone could have done that. That's the way it came. And to suggest that there's a link because Mr. Murphy tagged that song, I don't think that's exactly the circumstance. Anyone could have tagged that song. It's on the phone, but I don't believe there's any evidence that would suggest it's Mr. Murphy that did so.
Okay, so just so I'm trying to understand exactly what this is, it's a screenshot on Mr. Rashad Murphy's phone that depicts a homicide scene with the Young and Aces song tagged as part of the depiction of the homicide scene. Is that
And it's
correct?
kind of a far away
Just-
shot.
we can show you on our computer if you want to see it.
Yeah, let me just. And remind me, what is this relevant to, State, in your opinion?
Judge, it's relevant because Young and Ace, who is a member of ATK, this again is going to be
I gotta pause it right there. Did she just say it's relevant because Young and Ace is a member of ATK? Yikes.
corroboration of the gang expert's testimony that 1200 and ATK are allied, and they're allied against 6 Block. And again, this is on Rashad Murphy, a documented member of 1200, and it is relevant because he has on his phone a screenshot, and just like Mr. Gonzalez says, it's going to be at issue attribution, who this phone is being utilized for. We have it with Mr. Rashad Murphy when he's at the Walmart. We have it in the vehicle, the suspect vehicle, when he is arrested. And of course, it never comes to Tampa. So this is a shared phone between him and his girlfriend, Charmaine Steiger. But obviously, with the additional other information that is located on that phone that is relevant to this crime, any sort of connection to the gang is important and probative. But again, this is I know we are not suggesting this Jacksonville murder. We have been explained that it is a Jacksonville youth that is depicted in that picture. We would redact that out. We're not going to go there. I am more interested in the fact and that Young and Ace's song is specifically tagged and is screenshotted on his phone.
By someone and could have gone to tens, if not hundreds of thousands of people as well.
Right, I understand that kind of goes more towards, again, weight. So I will, on 26A, state stipulates it's not going to introduce the photo of the Jacksonville homicide, so it's granted as to that and denied as to the remainder of 26A. 26B is denied, 26C is denied, 26D is granted. Okay, I think that's it from that motion, correct, Mr.?
Judge, 26C granted in part.
Well, it's a photo. The photograph itself does have relevance because it does show the person in the photo with the, according to the state's theory, the similar black combat boots and black pants. So that, for that purpose, it is more probative than prejudicial. So I denied it. Denied the motion and limine to keep it out. So I think that's it for that motion, correct?
Yes, Judge, it is.
Okay. Okay, Davion Murphy, defendant's motion in limine.
Judge, we've obviously, Nixon argued again for Davion Murphy. We've argued the certification of Mr. Davion Murphy as an associate of Gang 1200, so we're not going to reiterate that. That's already before the court. We're arguing paragraph number 2, and that is that the state may intend to introduce the fact that there was a gap of about 6 months from the time that the warrants were issued for Mr. Davion Murphy's arrest until the time that he was in fact taken into custody as consciousness of guilt. I submit all that they have, basically, as I understand it, is the time frame itself, and not that I'm aware of. In fact, as we speak, I'm still not absolutely certain how it was that Mr. Davion Murphy was even identified to be arrested. That I don't have that information. But we would allege that there is no consciousness of guilt simply because of the time frame from the issuance of the warrant for his arrest and the time that he was actually arrested.
Okay,
Just, I'm sorry, what motion are we on? Because I'm.
it's Davion Murphy. It's titled Defendant's Motion in Limine. And in that motion, Mr. Sonardi is asking, 1, that the defendant's prior certification of being a gang member of the 1200 gang be excluded. 2, the approximate 6-month lapse in time of the defendant's arrest following the issuance of defendant's arrest warrant. And 3, photos of the deceased victims. When you, what are you referring to when you say the photos of the deceased victims?
Sorry.
When you say photos of the deceased victims,
Right, the autopsy photo. Oh, I'm sorry, it should be victim.
yes, that confused me a bit.
I'm going to ask the court to reserve on that, and we wait to see which photos exactly the
Okay,
state intends to introduce. We can address it at that time.
okay. So are you now with me on what motion this is?
No, Judge, I don't think I have that one actually, but I can, if we go one by one, I'll be able to respond.
So the first one is the defendant's prior certification of being a gang member of the 1200 gang. And are you, you talking about a gang expert testifying as to Mr. Davion Murphy being previously certified before he went to prison? Is that what you're referring to?
That certification expired because of the 5-year lapse. So now he's been designated in some manner, allegedly as an associate with the 1200 gang.
Okay, so state, do you agree as far as the prior certification?
Judge.
Sure. No, Your Honor. I think that Mr. Sonardi's argument is regarding the earlier certification from Jacksonville
Right.
and Mr. Murphy's affiliation there. He still meets the statutory criteria. So it changes nothing about the state's argument because he went to prison and then in prison still met the criteria just under the cutthroat gang instead of a 1200 designation. So he still met the criteria. If the argument is that Jacksonville would be permitted or not to testify that he was in fact documented in Jacksonville before he went to prison, then the state has no objection. That's accurate.
That's what I'm hearing, is that you're talking about the previous certification
Correct.
before he went to prison.
Correct. And my understanding is under 874 that previous certification expires after
Right.
5 years. And that he would have to be recertified, which he was not. He was designated as an associate.
Right. Which is what the state's seeking to prove, that he's an associate, not a member, correct?
That Mr. Davion Murphy
Yeah.
is a gang member.
I thought you told me associate.
That we,
Judge, I believe he is.
He meets all of the criteria for gang member before and after.
I thought I read somewhere that Isaiah Chance, member of ATK, Rashad Murphy, member of 1200, Davion Murphy, associate of 1200.
Member of 1200, the only associate label that has been lodged against any defendant is for Sean Gathright because of the criteria of association. Davion Murphy, both before and after his release from prison, met more than one criteria.
Yeah, the yes.
In the indictment.
well, I'm not clear exactly as to what it is, the criteria that the state has relied on to certify Mr. Davion Murphy as a gang member of 12.
So much. I was wondering what that was talking in the back of my thing. Guys, give us 1 second. We about to listen to the verdict in one of the cases that we had. We still have some more of this going on, but let's go into this verdict real quick.
I will not allow them to be subjected to any disturbance. This matter is very important, obviously, to the people of the state of Michigan, to Mr. Warner, and to Ms. Warner's family. Regardless of what that verdict is, I will not tolerate any outbursts, remarks made, or otherwise undignified behavior. If that does occur, the person responsible will be removed from the courtroom, or depending on the severity, taken into custody, and there will be contempt proceedings to address any violation of this order. Everyone must maintain control of their emotions. If you do not, or you do not think you'll be able to, you should take this opportunity to step outside of the courtroom. Because again, I will not subject the jury to any form of harassment. All right, are the people ready to receive the verdict?
Yes, Your Honor.
Defense ready to receive the verdict?
Yes, Your Honor.
You may be seated. Thank you. Ladies and gentlemen of the jury, would the foreperson of the jury, without telling me what the verdict is, let me know whether in fact you have reached a verdict?
We have, Your Honor.
Would you pass that to the bailiff, please? Madam Clerk, would you please read the verdict?
Members of the jury, listen to your verdict as recorded. You do say upon your oaths that you find the defendant, Dale Warner, as to count 1, guilty of second-degree murder. As to count 2, guilty of tampering with evidence. So say you, Mr. Foreperson. So say you, members of the jury.
Would either the people or the defense wish to have the jury polled?
Yes, please, Your Honor.
Madam Clerk, would you please poll the jurors?
I will call you by seat number as you are seated in the jury box. If you agree with the verdict, you will say yes. If you disagree with the verdict, you will say no. Seat number 1.
Yes.
Seat number 3.
Yes.
Seat number 4.
Yes.
Seat number 6.
Yes.
Seat number 7.
Yes.
Seat number 8.
Yes.
Seat number 9.
Yes.
Seat number 10.
Yes.
Seat number 12.
Yes.
Seat number 13.
Yes.
Seat number 15.
Yes.
Seat number 16.
Yes.
Thank you.
Ladies and gentlemen, I want to thank you once again for your service in this matter. As I indicated at the outset of the trial, jury service is one of the most important functions that members of a free society are asked to perform. At this point, I will excuse you to return to the jury room. If you wouldn't mind, I'd ask you to wait there for a few minutes and have some additional comments I'd like to make in private.
Well, this verdict is not surprising to anybody. The only thing that was surprising to me, they only had 3 counts that was it 2 or 3? They didn't have that many counts to actually look at, and it took them forever to come up with this verdict. I don't even know what they was back there deliberating now, but
You can be seated. Thank you.
we're going back into the Foolio hearing in 1 second.
Sentencing date and the first opportunity would be May 7th at 8:15 a.m. Does that work for the people?
I'm sorry, Your Honor, what time? May 7th at 8:15, you said?
Correct.
Okay, thank you.
The 7th and then through the following week do not work for me.
Okay,
Mm.
so through the following week,
Correct.
so that would put us out to May 28th would be the next available opportunity.
That would work.
I'm scheduled to be in a trial in Macomb.
Well, dang.
Okay. Would that be for 29th as well?
Yes,
How about June 4th?
unfortunately, I'll be out of the country.
Okay.
And when would you be returning?
I could be back for June 18th.
We just getting our sentencing day.
Does not work with, that week does not work with court schedule, so we'd be looking at June 25th.
We're in trial in Calhoun.
Dang. Just don't sentence him.
If May 7th works, I can make May 7th work. Does that
Okay.
work for you?
Yes, it does.
Okay.
Okay. So May 7th then at 8:15 a.m.
Thank you, Your Honor.
Thank you.
Is there anything else that we need to address on the record this afternoon?
No, thank you.
No, thank you, Your Honor.
All right. Thank you all for your time then. Court will be in recess.
Okay.
You want to make me briefly approach? Thank you.
So we'll show the sentencing when they have the sentencing for the statements and things like that. I just seen the message from Susie in Discord. I will change that. My apology. I didn't mean to do that. Okay, guys, let's go back into our Foolio trial coverage. Let me take us back over there.
Yeah, I don't know. I can't recall now where I read that because I had made a note a while ago that the state was seeking to prove that Rashad Murphy and Isaiah Chance were members and Davion Murphy was an associate.
Correct.
So since there appears to be some confusion, I would suggest a
Judge, I can speak to that.
Okay.
Early on, when we went to the grand jury, he was qualifying as an associate based on the prior certification and the fact that after he went to prison, Mr. Sonardi is correct that they were purging their records. However, based on the fact that he still had that tattoos, he still met the criteria of associate. Mr. Harmon has uncovered some Department of Corrections that we are working to get the STAR report, which shows that he still, even when he went in prison, was connected to a gang. It was a prison gang. And so factually, we believe that we would be able to present enough evidence to the jury to show that the defendant was a gang member and met the criteria when the offense occurred.
Well, correct. We don't have that evidence. That I understand what the state's intentions are at this juncture, but we do not have that.
We do in fact.
Wait a minute, guys. Can y'all hear the courtroom feed? I just want to make sure that everybody can hear the feed since we were switching from one courtroom to another courtroom. I don't want to have any issues with our sound. Sometimes it messes up the sound on there. Okay, good. Awesome. Awesomeness. SD, I sent it to therapist. She gonna make the bong emoji. So as soon as she make it, she'll load it up there for us. Yeah, so we can stop doing all this. We don't have to do all this puffing and inhaling and stuff. We'll just pass our bong. All right, here we go.
We do in fact have multiple.
Okay, it's
factors from the
supposed to
gang.
be one attorney per motion, just so you all know. So for the state, I need one person to argue this motion.
Judge, we apologize.
Okay, it's fine. So this needs to be sussed out a little bit more, it sounds like, because I was under the impression the state was going to attempt to establish he was an associate, but it sounds like Mr. Sonardi, now they're going to attempt to establish he was in fact a member. So regardless, it would be at the time of the offense, and his prior certification would have lapsed, expired, right?
Judge, the prior certification was based or should be based if there is nothing within the 5 years, Judge. That is not accurate.
Okay, so tell you what, okay, I'm going to reserve really Mr. Sonardi. We just need to see how
we can sort it out. Judge.
Yeah, how we can sort this out and state if you've got additional evidence, you need to get it turned over ASAP.
And Judge, the majority of the evidence has already been provided. There is just an additional STAR report that we're waiting on.
Okay. And then with regard, are you going to argue consciousness of guilt for the 6-month lapse between when the offense occurred until?
Yes, Your Honor.
Okay, based upon what?
Judge, there was a high-profile media press release that was done both by the Tampa Police Department as well as the Jacksonville Sheriff's Office when when the arrest warrants went out for all of the defendants. There was a press conference that was done, and 3 of the defendants immediately were arrested. And there was various attempts by Jacksonville Sheriff's Office to locate Davion Murphy in Jacksonville, and he was able to evade law enforcement for several months,
So you've got witnesses who are going to testify what they did in an attempt to locate Mr. Murphy and take him
Yes,
into
Your Honor.
custody?
As well as the video footage of the defendant the day that he was taken into custody. There are several statements that he himself makes when he's waiting for law enforcement to come into the room, where he is talking about how the best place for a person to hide is in plain sight. So there are statements that are made by himself on that video that shows a nexus that he was purposely hiding from law enforcement in this case.
Okay. All right. As to item 2, I'm going to deny the motion. That sounds like a weight versus admissibility. So reserve ruling on paragraphs 1 and 3, and then deny as to paragraph 2. I think
Thank you.
that's it for that motion, right?
Yes.
Okay, very good. Thank you. All right, Isaiah Chance, motion in limine. I think we may have covered a fair amount of this
We have, Your
already.
Honor. Justin Petridis, behalf of Mr. Chance.
So many.
For number 1, Judge, prior crimes, I'm really talking about 3 things. That October 7th attempted murder of Charles Jones, but I don't think the state's going to, I think they've stated they're not intending to.
They're not going to, no witness is going to take the stand. If it's an unsolved homicide, no witness, including law enforcement, is going to take the stand and say, well, I think it was.
Sure.
No one's going to opine.
And that goes to my other issue was during some detective.
As far as who the perpetrator was.
Correct.
Right, okay. Right, so
Some
that's,
detectives mentioned that they believe Mr. Chance is involved in other unsolved homicides, but
Right.
it's the same issue.
yeah, so that's granted.
And then he was arrested for resisting without violence during this case. I'm asking for that not to come up in this case.
Okay, he
He's
was
in
charged.
Jacksonville,
He was not charged with that, right?
not in this indictment.
Okay. Okay, granted.
And I think number 2, you've previously ruled on, that's the,
Yes. So, same ruling. Paragraph 3. Well, I've already, I guess, in the context of Mr. Murphy's motion, I've already ruled, so that would be denied. Okay. And paragraph 4. Again, at this point in time, I'm reserving ruling on the introduction of the rap videos until I know what the universe of proffered evidence is. So I'll reserve ruling as to paragraph 4.
I think you've ruled on.
So then we've got the issue of Davion Murphy's alleged statement after the death of Charles Jones. That kind of goes into our severance issue, so I'm going to reserve ruling on that one. Whether that would in fact be admissible against any of the other co-defendants if they were tried separately. Item number 6 has to do with the items found in Sean Gathwright's car. That will be denied. 7 would be the search of Sean Gathwright's home. That will be denied. Paragraph 8 would be the items found in Mr. Chance's residence. I think the state agreed to some,
Yes, Your Honor.
correct? So it would be as previously ruled.
And then I think you wanted to see the picture of the Glock switch. And
Yeah, the notes.
Yes.
Yeah, I need to see that. So I will, I think I can't even remember now. I think I granted some, reserve ruling on some. The clerk has my notes, so I can't remember. So as I previously ruled in the motion for that Mr. Gonzalez argued on behalf of Rashad Murphy. Okay, and then we've got the Glock 9mm and the firearm. I think the state agreed to that one, right? With regards to Mr. Chance?
Yes.
Okay, so that one's paragraph 9 is granted. Paragraph 10, the bully down poster, that's denied. 11, the notes, that's the one I've reserved ruling on.
that's an error, Judge. I put that twice.
That's fine.
Okay.
12,
So this goes to the history. This is,
okay, that one is denied. 13 Has to do with the social media post on November 19th, 2023.
Goes to allowing an expert to interpret the social media posts.
Okay, and I'm assuming, State, you're going to seek to introduce this?
Yes, Your Honor.
Okay, so that one's denied. 14, the Cash App transaction.
This is both the transaction and describing what an expert believes the basis behind the transaction is. It's simply a transaction of Jacory Rivers paying.
Right, this is for the Airbnb though, right?
Yes.
Okay, right, so,
Jacory Rivers is not going to testify.
right. But I mean, the fact that the transaction occurred is admissible, you're just saying no one can opine what the reason was,
Correct, Your Honor.
right? State, you agree?
Judge, I agree, but it's certainly up to closing arguments.
Sure,
as
that's
to the
different.
amount. Yes.
We're just talking about the evidence. So the
Yes.
evidence, so 14 is granted as far as the evidence itself is admissible. I'm sorry, it's denied as to the evidence. It's granted as to any, the admissibility of the evidence is denied, but it's granted as to any opinion for why the transaction occurred. So denied in part, granted in part. Okay, 15,
You may have already ruled on this in general,
yeah,
just opining on phrases.
unless it's being offered, unless the opinion is part of expert opinion, right?
Yes, Your Honor.
Okay. So I guess it's technically denied, but it only comes in through potentially expert opinion,
Yes, Your Honor.
okay? Let me just make a note. All right, 16.
I don't think the state's intending to introduce these, but I don't want to speak for them.
Communications between Andrews and Chance.
Judge, we'd agree to 16.
Okay, granted. And I think 17, same, no one's
Same.
gonna opine as to Mr. Chance's purported involvement in the October 7, 2023 shooting of Charles Jones. 18,
It's about from a conversation in spaces.
okay. State, what's your response to this one? Are you saying these are, what are these?
Judge, those are relevant, Judge, and we would object. That is the conversation that happens a couple of weeks right before a homicide where he is, and actually not only are the public watching this, but law enforcement is actually watching it and recording it, and that is when Charles Jones is having a conversation with our victim asking about his foot. The October 7th of 2023 attempted murder that is also tied ballistically to this case. The victim was indeed shot in his foot. So that is relevant, as well as, again, the co-defendants in this case. When that is happening, Sean Gathright is receiving a message from Rashad Murphy where there is dialogue concerned about this happening on X because they have bigger plans. So certainly that is relevant and probative to this homicide.
Okay, 18 is denied. 19,
Did I understand Mr. Howard's going to testify, and obviously he could testify,
Judge, I
but
think that was 18. I'm
yeah,
sorry.
18 denied. We're moving on to 19.
we're just asking that he not be allowed to opine on what Mr. Chance meant by something Mr. Chance said to him, allegedly.
Okay, state what's your response?
Judge, we know that he could not comment on the defendant's state of mind, but certainly he can give his opinion as to their conversation that they were having.
Sure. So it's granted as to, and Mr. Howard opining as to Mr. Chance's state of mind. Okay, 20, again, this would seek to exclude Mr. Howard giving opinion testimony regarding social media posts allegedly made by Mr. Chance after the murder. State, what's your response?
Hold on 1 second, Judge. Judge, we, again, are not going to ask him, what Mr. Chance or the defendant, what he may have meant, but certainly he can testify as to seeing the post and the relevance, and the effect on the listener, how it was pertinent to him.
Okay, so it's granted as to opinion testimony. You can, again, opine as to Mr. Chance's, what he was in, what it meant when Mr. Chance posted what he did. You can testify to the facts. Okay, and then 21, any allegation, mention, inference, or indication, whether through witness testimony, picture, or attorney statements to the jury regarding Mr. Chance being the mastermind. Is the state going to argue he's the mastermind?
Judge, I do think based on the evidence as well as, Judge, I do believe that is appropriate for closing argument as long as it's based on the evidence that we produced during the trial. As far as eliciting that from a detective
Sure.
or anything of that nature,
No.
we certainly would not be doing
Okay,
that.
because the reason I asked, because it did, in the motion, it specifically said attorney statements. So to me, that seems that you would want to prevent the state from even arguing that.
Yes, Judge, but I would agree that I'm more interested in not having the detectives or
Okay.
witnesses.
All right, it's granted as to any witnesses, and it's denied as to the state's closing, assuming they've got evidence to back up their argument.
Yes, Your Honor.
Okay, that's it for Mr. Chance's motion and limine. Okay, are there any other motions? I don't have a pile of anything left.
I think that is it.
Okay, all right, very good. I think we had 59 motions, so we made pretty good progress. Okay, so I think the last thing we need to do is wrap up, and I asked you all, I've taken the motion to sever under advisement, and so my kind of last thing I want to hear from you is now that we at least have an idea as to the universe of evidence, what specific evidence you're going to argue on behalf of your client would be inadmissible if they were tried individually, sufficient to warrant a severance. Does anybody want to kick off?
I will, Judge.
Okay,
Judge, also, and I don't know the court's position on this. As you know, I filed a supplemental memorandum of law as it relates to severance issues, as I told the court that I would like to do last week when we finished with the severance argument. The state in turn responded to that. Is the court going to allow us to argue that as well?
you can.
Okay.
So, but
We can do this now, Judge, what the court asked.
Yeah, it's 2:37 in the afternoon. So if you wish to have further legal argument regarding the severance issue, that's fine. I would like you to first answer my question.
Certainly.
And then I'll give each of you 20 minutes to, in total. So it's 2:37. Mr. Gonzalez, you have the floor.
Judge, I did a filing, and essentially the items that I believe would be admissible, not admissible against Mr. Murphy and potentially is admissible about to other defendants. Number one, messages sent by Isaiah Chance to co-defendant Andrews, telling her that he needed to stay low and asked her to remain loyal. That was October 7th, 2023. The same day as the attempted murder of Charles Jones. And I expect Detective Nieder to testify that Mr. Chance and Mr. Gathright were suspects in that murder. I believe
Well,
that.
no, they're not going to testify to that. We've discussed that a couple of times now. No one's going to opine who the suspects are.
And whether or not it's admissible to Mr. Chance, I would suggest that if it is, it's not admissible to Mr. Murphy. Next would be judge on.
Because why?
Because number one, it's outside the scope of the conspiratorial time frame. Number two, it's not relevant as it relates to Mr. Murphy. What Mr. Chance indicated to Miss Andrews about that particular incident. Well, even if it relates to that particular incident, we don't even know if that statement relates to that incident. That would be the state's theory of prosecution. But in any event, it certainly would be impactful. Would be a minimizing word as it relates to what the jury could, the road they could go down, considering what effect it may have on Mr. Murphy.
Okay.
So,
all right, very good.
as it relates to two, that would be the recorded social media video where Mr. Chance is addressing Mr. Jones on X, saying, "Hey, Foolio, your foot okay, cuh? I got bigger fish to fry." Again, this, referring presumably, theory of prosecution, to the attempted murder on October 7th. It would be the same theory, the same reason for inadmissibility, may be admissible to Mr. Chance, and I believe not admissible to Mr. Murphy for the same reasons.
And that was that date also October 7th?
That date was June 6th of 2024.
Okay.
Next, judge, would be all items, but specifically, and the court's already ruled them to be admissible in general, and that is shell casings that are, and all items for that matter, that are found in Mr. Gathright's vehicle at the time of the search on June 26, 2024. And again, all of these incidents, judge, are post-conspiratorial, and ballistic comparison suggests that those casings match the October 7th attempted murder of Charles Jones. May impact Mr. Gathright, may impact Mr. Chance. Again, the same theory as it relates to the spillover, as to the thoughts that a jury may have as to Mr. Murphy's involvement. And I believe that would require severance. Same as it relates to all of the items on June 27th, post-conspiracy.
The items, the physical evidence found.
Yes, items of physical evidence in both circumstances. 26th and 27th as it relates to Gathright's residence and Gathright's vehicle. Next, judge. Chance's Instagram posts that he had to switch it up, coming different, all 2024, love you, brother, tagged music by Charles Jones.
What is the date of that?
That is November 23rd, 2023, pre-conspiratorial time frame, and tagging Antonio Tilley and Ghost 187 _. Detective Nieder, I believe, will testify that in his opinion, Chance was upset with ATK because they didn't get a get back for Tilley's murder in October of 2023, and that He had a falling out with ATK and was now associating with 1200. And then Detective Nieder opining that Ghost 187 is Rashad Murphy. Certainly potentially relevant and admissible as it relates to chance and under the same theories. In my estimation, and I believe based on the law, inadmissible as to Mr. Murphy. Next, Judge, and the court made some statements. It was not a ruling, but the court made some statements, as I understood it last week, with regard to celebratory statements made by Davion Murphy. Post-conspiratory, I'm coming home, my thirst is quenched, pop a bottle of Don Julio today. And although I don't believe the court made a formal ruling, my argument would be under the same theories and under the same time frame that those statements are post-conspiratorial in terms of the time frame. And although they may be admissible against Mr. Murphy, Davion, they should not be admissible against Mr. Rashad Murphy. Next, Judge, is categorized gang affiliation evidence. These next 1, 2, 3, 4, 5 incidents are, and I don't have any police reports on these things. I don't have any social media posts on any of these things. I don't have any pictures of any of these things. I don't have any videos of any of these things because they appear in Isaiah Chance's gang documentation FIR. So it is an evidence, and to the extent that the state would seek to introduce all of these varying pieces of evidence that I believe may be relevant to Isaiah Chance. Number one, to maybe segue into a gang certification or documentation, or as some type of extricably intertwined evidence. I don't know under what theory, but the only thing I have, and it's very detailed as to its generalities, there are no actual documents that we have been provided because I don't know that they exist. This is the FIR regarding Mr. Chance. For all of those same theories, and the dates are March of 24, July of 23, February of 24, December of 23, March of 24, all in that same time frame, which certainly is all extensively pre-conspiracy. My arguments being the same, they may be relevant and admissible as it relates to Mr. Chance, not admissible in my view as to Mr. Murphy.
And does your supplemental or your amended identify these with specificity, this gang affiliation?
No, Judge,
evidence?
these would be in my filing, a notice of filing. I did an itemized list of evidence admissible against co-defendants, but not the defendant. You asked Judge First to orally give it to you.
Yeah.
I just put it in written form.
Okay.
So it'd be a little bit more particularized.
Okay.
Finally, Judge, two more issues. Again, the bully down poster that the court has admitted or determined not to exclude in limine. My position again and that would be inclusive of all the other items. The court, declining to make it, a limited item and allowing it to be introduced, certainly it doesn't change the court's ruling, but it does change in my mind the ramifications as it relates to Mr. Murphy. And therefore, that bully down poster and the other items in Mr. Chance's residence, again, post-conspiracy, June 27th to 24. Although they are seized post-conspiracy, I assume the state's going to say they pertain to pre-conspiracy, not during conspiracy, but pre-conspiracy. And I would suggest again, potentially admissible as it relates to Mr. Chance, and I would tell the court not admissible as it relates to Mr. Murphy. Finally, Judge, there are Cash App records, and also Detective Ramos testified in his deposition about Mr. Chance. You heard about it a little bit earlier, that it's Mr. Chance's Cash App is rich on war. He's, he makes money killing people for the gang. And there are several entries to his Cash App. I don't recall whether they specifically reference transactions that the state is going to insinuate may be relevant to this or any other murder or shooting. But the records, even in general, with his handle being Mr. Rich on War, again, these are pre-conspiratorial. And additionally, Detective Ramos suggesting he's the mastermind. He handles the gang war, and he is involved in ongoing violent gang activity. Again, I would suggest to the court under all of the same theories as it relates to relevance, as it relates to character, as it relates to pre and post conspiratorial timeframes, might be admissible against Mr. Chance. And I would suggest to the court they, for a number of reasons, not admissible as to Mr. Murphy, and certainly would be extremely, extremely prejudicial.
Okay. All right, thank you. Okay, Mr. Sonardi, on behalf of Davion Murphy, do you have any additional specific items of evidence that you contend would be inadmissible if against Mr. Murphy if he were on trial alone?
In addition to those items that were already
Anything
identified.
other than Mr. Gonzalez just identified?
No, Your Honor, other than any of the social media posts did not involve Mr. Davion Murphy, and none of the rap videos involve Mr. Davion Murphy. We just incorporate all the other items identified as to Rashad Murphy that would not be admissible if Mr. Davion Murphy were tried individually.
Okay, very good. All right, Mr. Wise, on behalf of Mr. Gathright, any additional items, specific items of evidence that we've not already discussed?
Sort of, Your Honor. Again, I think Mr. Gathright is a little different in that he's not alleged to have been one of the gang members. So I think 5 of the 6 collateral incidents, I think, would not be admissible against him. Again, for 2 of those, he was a child when they transpired. But I think the only one that would have any relevance to him would be the alleged prior shooting of Charles Jones, and that's only because of the shell casings being found in the car. Otherwise, there's no connection whatsoever to him and the gangs. So I don't think really the bulk of the evidence that we've been hearing about, including the communications with Mr. Chance about switching gangs, things like that, I don't see any of that being admissible against Mr. Gathright if he were to be tried separately, because he's not alleged to have been really even an associate of these gangs. The same thing with the rap videos. Other than that, I think it's really the same individual pieces of evidence that Mr. Gonzalez pointed out. Again, I recognize a lot of what he pointed out are things that, do relate to Mr. Gathright, being the things that found in the car. But all of these collateral incidents and the discussions of the gangs and whatnot, I don't believe do. The one thing that I don't know if was brought up, but it was the subject of one of the motions limited just a moment ago, is the alleged consciousness of guilt of the other Mr. Murphy, which is something I don't think would be admissible against any of the other defendants if they were tried separately. And that being the allegation that he went to another jurisdiction or whatnot.
Okay. All right, very good. And okay, finally, as to Mr. Chance, Mr. Petratus, any additional items of evidence that have not previously been discussed?
Judge, I think Mr. Gonzalez spoke about Davion Murphy's post-conspiracy statements. We would also add, we believe, Robert Howard's testimony when it comes specifically to Rashad Murphy, alleged threats he may have made in the history of Robert Howard being convicted of a crime involving a quote-unquote brother of Rashad Murphy. we haven't gotten into this yet, but the drill rap videos, which none of which include Mr. Chance, I would argue, and then any historical gang information regarding 1200. Obviously, Mr. Chance has documented ATK, or that's the allegation. We would argue anything involving 1200 to be prejudicial.
Okay, all right, State, Mrs. Murray, you gonna argue this?
I will try, Your Honor. If I can clarify, does the court wish for me to address the arguments now that were made by each of the defense counsels as it relates to the drill rap videos, or reserve that for when the court has the videos before it?
Yeah, just reserve for the time being on the drill rap videos, just until we know what actually is gonna come in, so.
Yes, Your Honor.
So I guess I just need to know from you, with regard to the identified items of evidence, what's the state's position as far as whether or not those would be admissible against all of these defendants if they were tried individually?
As stated by each of the defense counsels at this point, in its totality, the state's position is that as evidence of principle and as evidence in support of the conspiracy, all of the evidence would be admissible in trial against each of the defendants. Most specifically, because in establishing that one defendant committed this crime, the state would in fact be proving up that each of the co-defendants were in some way related to the offense. If they were gang members, we would still present evidence of that as the co-defendant being a gang member. We would still present each of the articles of evidence that have been listed. I'll go specifically for the court, but the overall position is that the evidence would still be admissible in each of these defendants' cases. So if
let's start with the messages sent by Isaiah Chance to the co-defendant Alicia Andrews on or about October 7th of 2023. Would those be admissible against Mr. Davion Murphy, Rashad Murphy, or Sean Gathright if they went to trial individually?
Yes, Your Honor. So we would ask to submit those articles of evidence as evidence of motive in this case, because we have the ballistics evidence that links that earlier shooting to the subsequent homicide of Mr. Jones. We would ask for a limiting instruction in presenting that evidence, but we would certainly ask to admit that evidence in each of their trials.
Okay. I'm not sure. All right. And what about the recorded video where Isaiah Chance responded? I think it was dated June 6th of 2024, where he's responding to, is it Julio Foolio? Who's he responding to? Charles
Yes,
Jones?
Your Honor. They're on Spaces. That's the one where verbally back and forth they are communicating with each other. Mr. Chance is posting on his social media accounts and is going back and forth with Mr. Jones. That, in addition to Sean Gathright and Rashad Murphy then discussing Sean Gathwright's boy going crazy on the internet on his social media accounts and telling him to calm down because they have bigger things to deal with. Absolutely, the state would be seeking to admit the evidence against each and every defendant, including Davion Murphy, given we've charged conspiracy in this case.
Okay. And then obviously the physical evidence that was found at Sean Gathwright's car, at his residence.
Same argument that was previously made and seeking the same ruling from the court.
Okay. What about Isaiah Chance's Instagram post from November 23rd of 23? Why is that? Why would that come in against all the other co-defendants?
So that post is made a month after the earlier attempt on Mr. Jones's life. For the same reason that Mr. Chance and Mr. Gathright were linked to that offense. This is the same offense that we're discussing when Mr. Chance sends the messages to Miss Andrews in the same month about the earlier attempt on Mr. Jones's life. The law enforcement officers from Jacksonville will talk about how at the same time, it's not just Mr. Jones's life that was attempted at the October 7th date, but in the hours before Mr. Jones's life was taken, Mr. Tilley's life was taken. So the posts from Isaiah Chance then subsequent to that are about how he is transitioning from one gang over to the other because he is upset with how his current gang has represented or come forward in support of the death or homicide that occurred with Antonio Tilley. So when he posts this, he actually tags Ghost 187. At the time of Charles Jones and Antonio Tilley's homicide, Chance was associated with ATK. This is the detective's discussion or describing some of the detective's discussion about how he transitions from ATK to 1200 and how he tags Ghost 187, who we ultimately linked to Rashad Murphy, a 1200 member. So when law enforcement says we saw that he started posting with and he was in music videos with, or whatever it was, that there was some relationship between ATK and 1200, this is just evidence of that. The defendant posts this to his social media account. It's actually a video with a
Isaiah
caption.
Chance does.
Yes.
Okay, and then what's your argument regarding the post-conspiracy celebratory post by Davion Murphy? How is that admissible against the other co-defendants?
As it relates to Sean Gathright, it comes from Sean Gathwright's device. The timing of the post, or they're actually text messages that are immediately sent after the homicide itself. The argument from defense that it's definitely Davion Murphy is not one that the state also takes. Yes, investigators reached out to the recipients of those messages to try and ascertain whether it was Rashad Murphy, Davion Murphy, or Sean Gathright, because it comes from Mr. Gathwright's device. But the messages themselves, or the content of the messages, are not being offered by the state for their truth. I have no idea if at the time Mr. Murphy or whomever sent the message was going home or had a thirst quenched. Instead, it goes to the identification of the suspects, it goes to the intent in this case, and it goes to knowledge. So we would have we would seek to introduce against each of the defendants in a trial these messages that come from Mr. Gathwright's device, but were signed Murph. There is no direct evidence for us to establish whether it was Davion Murphy or Rashad Murphy. The only thing that we have is investigators attempting to follow up with the persons who received the messages.
And that was on Mr. Gathwright's phone?
Correct, Your Honor.
Okay. Okay. Some of this I've already basically ruled on. The gang affiliation evidence as to Isaiah Chance, I'm assuming you would argue that you would seek to introduce that, and if these gentlemen were tried individually, correct?
Yes, Your Honor.
The same with the bully down poster, correct?
Yes, Your Honor. Same argument.
And the Cash App records for the rental of the Airbnb, right?
Same argument. Yes, Your Honor.
And what about Robert Howard's testimony of threats made by Isaiah Chance?
I think Mr. Howard's testimony were threats by Rashad Murphy, if I'm not mistaken. I think that was Mr. Petridis' argument. Is that what you're referring to?
I think that's what he was referring to. Mr. Petridis was arguing.
I just want to make sure we're arguing the right thing. Okay, so yes, Mr. Howard did receive some phone calls or voicemails from Rashad Murphy leading up to the offense itself. Those are relevant to premeditation, motive, and intent in this case, and as it relates to all of the defendants. Mr. Chance is alleged by Robert Howard to have made similar calls, not threatening in any manner, but calls in advance of the offense itself in anticipation of the offense occurring or something occurring in Tampa. And that evidence, again, would be sought to be introduced given all of the defendants acted as a part of a conspiracy.
Okay, thank you. All right, so I'll start with you, Mr. Gonzalez. What is your response to the state's contention that Davion Murphy's celebratory post-homicide of Mr. Jones would be admissible against your client, and that it's not hearsay because they're not trying to prove the truth of the matter, they're trying to prove identity?
Identity as to
who the perpetrators were.
Well, Judge, I can tell you that as I remember it, the two messages that went out went to two separate people. Although law enforcement was not able to talk to one of the two, they did speak to one of the two, and Detective Ramos says it was Davion Murphy. I spoke to that person, and that person indicated to me that it was Davion Murphy that sent her that post or sent her that message. I don't know details on that. I am referring to Detective Ramos's testimony, and in that light, and the fact that, as I believe it, Mr. Davion Murphy has been identified, and I think Detective Ramos will testify as such, at least to one of those two posts, that in and of itself, it would not be relevant and it would not be admissible as to Rashad Murphy. And simply to identify, okay, if it's going to identify anybody, it's going to identify Davion Murphy because that's what the person on the other end of it told Detective Ramos. So that would be my position as to its relevance as it relates to Mr. Rashad Murphy.
Okay, so so I'm not so sure, as I indicated, I'm not sure about the celebratory post homicide, and I'm not sure about the message being sent by Isaiah Chance to Alicia Andrews after the October 7, 2023. I'm not sure. And I know I don't want to roll the dice in a death penalty case. So state, you just really need to think about this because I'm not sure about those two. They would be admissible against all of the defendants. I don't know.
Yes, Your Honor.
So,
Judge, I know that you said the Alicia Andrew and message to from Charles, I'm sorry, Isaiah Chance. What was the second one? The post by Davey
Yep.
Murphy afterwards?
Mhm.
Okay.
as I sit
And Your
here,
Honor, I just want to confirm, I understand that in the motion from the defense are referred to as celebratory posts, but in confirming with the defense, Mr. Gonzalez is actually referencing the text messages from Mr. Gathwright's device. 2 sets of text messages, not posts, because there are posts.
Again, my literacy when it comes to,
let me see them, please.
I've seen them, Judge. So. And Judge, I might take this one step further, is I believe that when Detective Ramos spoke to one of these ladies, she in fact knew Davion Murphy, but did not know Rashad Murphy, as I remember it. And I could be wrong. I don't think I am, but I think that inquiry was made of Detective Ramos in deposition.
So I wonder if the judge is telling the state,
Okay.
y'all may want to consider leaving this one because I don't know if this is the
As I indicated, I'm not sure. And I'm not really inclined to roll the dice in a death penalty case. Okay? So state, it seems to me you're gonna have to pick.
And you're referring to the text messages and the postings as well, or no?
No, it's just the post that was found on Sean Gathwright's phone, post homicide, and then the message from Isaiah Chance to Alicia Andrews on or about October 7th, telling her to stay low and be loyal. Okay.
Is the court making a ruling on the celebratory post that we're discussing that from Gathwright's phone?
Yes. I'm saying that I'm not sure that those would come in
But
against.
you're not ruling.
Well, I basically am. I'm telling the state they're gonna have to kind of pick. So I don't, as I sit here right now, unless something changes my mind, I'm not sure that those 2 items of evidence would come in against all of the defendants. So the first one would come in potentially against Isaiah Chance regarding his conversation with Miss Andrews. And the item found on Sean Gathwright's phone would conceivably come in against him. I'm not sure they would come in against the other co-defendants if they were tried individually. And even though it's not a brutal problem, does it become a other problem, meaning it somehow significantly impacts the defenses of the other co-defendants? And I don't know, but I'm being extremely cautious. Okay? So basically what I'm telling the state is if they really want this evidence to come in, then I would be inclined to sever. If not, then I wouldn't be. Okay? So.
And Judge, can I ask one follow-up in respect or in regards to that? If you are inclined to sever, would it be picking more than one jury at the same time or separate trials?
Well, that's a good question. Probably more than one jury. I gotta think about it. So it's kind of an open question mark at this point, but I'm not sure. Okay. So State, you want some time to think about it and let me know?
Yes.
Okay. All right. So how much time do you need to respond? You want to file something?
Yes.
Okay.
Judge, can we have we need to talk about it and
Sure.
Have till next week.
Okay. Sure. That's fine. So next Friday?
Yes, Judge.
All right. So you guys have until next Friday, the 13th, just to file something. If there's additional case law or additional argument you want me to consider, but you know my concerns.
Yes, yes, yes.
Okay. Okay. All right. I think that's it for today. We covered everything.
I want to put something on the record, Judge.
Sure.
Judge, I had previously asked the court whether or not I could argue the supplemental memorandum as it relates to severance. And that was mainly, I argued extensively last week with regard to the grounds for severance, and the court has my motion that's whatever, 35 pages long. And that should be an amended. I hope the court has it amended.
Yes.
Okay.
Yes. An amended. Yes.
So Judge, essentially, I just want to say that at the conclusion of the severance hearing, the court didn't issue a ruling, still hasn't, obviously, taken it under advisement, but indicated a concern or a question to me as to whether or not pre and post conspiratorial evidence may be admissible against all defendants if the court determines that it's inextricably intertwined. And also asking, is there some case law or is there a position in the law as it relates to co-conspirator statements versus co-conspirator evidence?
Mm-hmm.
And I'm not going to argue this supplemental filing. I think it speaks for itself.
Okay.
It identifies case law. I will tell you, in my opinion, there's not much Florida state court law on it because I think it's a settled issue. There is some federal court law that I've cited to the court, and I know the state differs from me, and she has made that plainly clear in her response. But to the extent that that an act or a declaration should be separated and should be considered under different theories, I think is not the case.
Okay.
And so I would suggest to the court that for as long as I think we all should remember, the law clearly establishes that acts or statements of a co-conspirator are only admissible against another co-defendant if those acts or statements are made within furtherance of the underlying conspiracy. And I think that all evidence attributable to a co-defendant, but not attributable to Mr. Murphy, that especially falls outside that conspiratorial range. Because every one of the things we talked about that the court has considered, we are still in this post and pre, and we're also outside of that temporal range, and also discussing an act or a statement. And I think the memorandum sets out, in my mind, what is required, what the case law says, and how it establishes that the spillover prejudice that will exist, and despite any instruction from the court, by the way, despite any limiting instruction, the damage would be so significant that I don't believe a jury could compartmentalize in that particular circumstance. And as it relates to the state's response, Judge, I'm just going to say, generally, the crux of this issue is that the state, when it applies a co-conspirator rule to only hearsay, the rule has existed for decades before the hearsay rule was created, and it was never limited to statements. The hearsay rule merely codifies the existing law as it applies to hearsay. And other acts committed by the defendant may be admissible in conspiracy cases to show the evolution of the conspiracy. The key is that those should be acts by the defendant. It has never been applied that I'm aware of to a non-participating co-defendant. And that's just my response to the state's response, if you will. Thank you, Judge.
Okay, thank you. And the clerk just asked me, Rashad Murphy's fourth motion in limine, did we discuss that? I feel like we did, but maybe.
We did, Judge.
We did, Your Honor.
Hold on, I'm looking for it. The fifth, I have the third, where's the fourth?
There was a short motion concerning opinion evidence, and I cited the Bentley case. Or inquired.
Yeah. Yes. Yeah, there's the the defendant, Rashad Murphy's second motion in limine.
No, Judge, you see number 13 on the sheet that I gave you? 13.
Yes.
That was a last minute, like one at the bottom, but we had already addressed the fourth one with the opinion. So I
Okay.
wasn't sure if we needed.
All I see is Rashad Murphy's fourth motion in limine. I thought have I not ruled on that
Yeah,
yet?
but that was a ruling on number, that was the same one. It was the opinion one, I thought, but then that was number 11. You see
Yeah.
number 11,
Yes.
which is like the same motion, but. they
Yeah.
were- isn't
I
this
think,
up there, Judge?
yes, I think that's just a typo
Okay,
from the
okay.
state
All right.
in the state's
was
master
granted,
list.
Okay,
Yeah,
Well,
yeah.
then I got it then.
Yeah,
I
yeah.
wasn't sure about that one.
Okay, yeah, that's just a typo.
Okay.
So, and then I did, and if I didn't officially state it, Isaiah Chance's motion to adopt and conform applicable motions of all co-defendants, that's granted.
Okay, thank you.
Okay?
I got them all.
Okay. All right. Well, very good. I will take a look again at the updated case law that you've provided me, as well as the state's response. And then I will await clarification from the state regarding the items of evidence that I have a concern about. And then I will issue a ruling. Okay? Okay. I think we're done for today. All right. Very good.
Okay. So I guess to recap what we kind of heard today, the prosecution team got some things to decide. Is it really, really that important to get that text message in from Chance to Alicia saying, hold me down, be loyal? Do they really need that in? I don't know if they really need that in to make their case, per se. And this is after the first attempt on Julio Foolio's life, right? So that's what they're talking about. He sent her a text message letting her know, and that did come in during her trial. I don't know if that's worth it. And then we have Sean Gaffright. He had some post on Instagram or some kind of social media where he was celebrating after the death of Foolio. I don't know. Do they really need? I guess maybe they may want that really in there because a certain fact that shows that he was excited about it or that he was celebrating it for the jury to see it. Maybe for that reason. And then the next issue is that the judge is saying she doesn't know if it would be 2 juries or if they have to do multiple trials. And I think, me personally, and just in my opinion, I really think like for these, because everything else kind of it overlaps as far as the evidence. Everything is overlapping each other. So besides these 2 things that stuck out like a sore thumb to the judge, I think that they should be okay with having like maybe 2 juries and just send them out the room like they did in the case whole trial. They would send the jury out when it didn't apply to one of the defendants. I mean, even though it was very tedious, but most of all the evidence goes over to, it's across the board. Like for one thing that applies, and a lot of this stuff even came into her trial. So I do think that, I don't know what they're going to decide. We'll find out on the 13th. But, you know, it sounds like the judge is saying, well, either y'all can't have y'all cake and eat it too. So what I'm going to tell y'all is this is your option. Either y'all going to decide that y'all don't really need this, or we're going to decide that y'all need this really bad, and we going to split these cases up because it's just too prejudicial against the other party. So, you know, prosecutors are definitely saying that the defendants acted together. They coordinated all of this stuff to unalive Julio. We got Sean, who was the weapons man. He got all the weapons. You know, we've seen a video of them loading up. I don't know what they were thinking, why they thought this, and how they didn't think they were gonna get caught. But you have to turn off Granny's ring cam when you decide that you're about to go commit a crime. But anywho, you can clearly see him on the camera. You can clearly see Isaiah Chance, and you can clearly see Alicia Andrews, right? And this is coming out of the house with the weapons. So, and then we have these other two, you know, thing one and thing two, as we have named them. They driving up there. And then we have the video surveillance of all of these things happening. And you know, guys, they are trying to say that in some ways the state wants to argue that Isaiah Chance was the leader. So according to investigators, it was one car acted as a lookout, Isaiah Chance and Alicia Andrews, allegedly. Well, she's been convicted, and another car contained, the shooters. And all the phone data and all the surveillance video will put them all together. And that's why the conspiracy theory is exactly, they want to keep everybody together so it can almost connect. And the only reason why Alicia Andrews' trial is not with their trial, just so y'all know, is because they were not going for the DP for her. So they kind of let hers kind of go on the other side. So, and I guess with the defense, a lot of spillover evidence, and that's, evidence that may be against one defendant, but to make that defendant guilty or make that defendant look guilty, that can go over to somebody else's case. So say, for instance, they're going to bring in all this gang information in regards to people that are documented to be in the gang. But the only person that is not documented to be in the gang is Sean Gathright. So as a juror, would that blind your judgment? Like, okay, birds of a feather flock together, that type of situation. So here we got that. And then the co-defendant statements, like statements, text, or communication involving one defendant could be used indirectly against others. And that's where they were talking about the Alicia Andrews text message. So I think that we got a lot to do. I was trying to check and see if they put any updates in regards to Alicia Andrews' hearing that she had today. I don't see anything just yet. So I am still waiting. I'm gonna wait and see it overnight. Maybe since we do not have trial in the morning for Corey, maybe I'll do a little short bit on Alicia Andrews in the morning. Hopefully we have the rest of our documentations for that one. And that's the other thing. I think that they trying to present that. I still sent to something that said if they split, someone falls, they cook. Either way. I think that's another thing that they want to do. I think they want everybody to kind of like start blaming each other, maybe. Maybe that's part of it. Zim says, in Alicia's case, it was set up so she didn't have any idea about anything her boyfriend, what Isaiah was. Violent towards her, there are so many inconsistencies, but little evidence to prove otherwise. Well, I think that, and we'll get into more about her new trial, what she requesting, what they are fighting for, and I'll give you my thoughts and opinions on that, because I definitely have some thoughts and opinions on that one, and we'll do that tomorrow morning. I just want to see what happened in court today, because they did not show it. But I want to see what happened in court once they load up the documents, because I've been looking all day to kind of see. Lynn says exactly. The states get satisfaction from getting gang members to fold on each other. Yeah. Or if not, we don't need none of y'all to fold. We don't even want the case to be severed. We want to take all of you mofos down at the same time. I think the state feel like they got a good enough case. I just wonder if they feel like it's good enough to keep those two items that the judge is kind of questioning that may not work for all the other defendants. She being extra careful after being recruited. Yeah. And also, and I appreciate, welcome in, Sir Rock. I appreciate that she is being extra careful in regards to this, because a certain fact that it's a DP case. Like, I mean, regardless, we don't know if the jury will go to the second phase and, and they have to decide whether these young men get DP or not. But you definitely don't want nobody going to DP because you done let some evidence in that makes Isaiah Chance look guilty, but doesn't make me look guilty. Like, got to turn off any cams and don't bring no damn. Right. Please don't bring any of that stuff. Keep it all at home. I think he thought about bringing Alicia like she was the deep, and he probably could have very well said, babe, can I use your phone? And she just want to hang out with her boo. And he up here texting his homeboys from her phone. I can see that very much well going down. Y'all know I was with Alicia all until I was not. Door camera, Tesla in the parking lot. There's no place left without cameras, right? Even right. That got the little shoot down there because it got from a car. I'm pretty sure some cameras on the thing, but that's how the Murphy brother, because they was coming from that those angles, the thing 1 and thing 2, the Murphy cousins. But yeah. He got the closest tie to the leader of ATK, Young and Ace. And I was really surprised that they said that, and even in Alicia Andrews' trial, when they brought up Young and Ace, I was like, oh man, why is his name being brought up in this trial like this? Like, if y'all really saying that Young and Ace is the leader and he is the gang, he's in this gang, I can't understand why. If that is the case, why no charges? Where's the RICO? Not to say it out. What's going on? Like, I hate that they even throwing that out there, but allegedly that's what they're doing. Well, that's what she did today. SD said, crime does not pay. I think everybody agrees with that one. And the younger ones repeat the whole thing, sadly. Exactly. They the same old thing, same cycle. Nobody in this case is over 31 years old, okay? It's just all weird to me. It's like, I think that they feel that they're invincible in ways, because I felt like Julio had no rhyme and reason to be where he was at. They all told him, people are looking for you. He was putting his address, and I'm not victim blaming, saying that he should not live his life. But when you move a certain way, you gotta know how to move a different way, right? You don't post everywhere where your party gonna be at, where you gonna be. They be all on a Instagram. I'm gonna be over here at Club A, and at 11:59 I'm going to Club B, and at 12:22 and 33 seconds I'm gonna be back at the Airbnb, and then I'm gonna be at the hotel. Like, it's like blow by blow. Like, dang. You said now they all sitting up in court looking like they scared, right? Like, he looking like he's zoned out. I don't know what they like. He can't handle it. I guess you can't handle the truth. Flip on each other. Yeah. He's like, thing one, lost in the sauce. Yep. I don't know what they gonna do. I don't know what they gonna do. They better figure it out. If they flip, that will require them to testify. And I don't see them testifying at all. So what I would like to say is that, and I don't know how this stuff works to that degree, but we'll get into it more when we do Alicia Andrews stuff tomorrow. But guys, I got some real thoughts about that because it almost like in the Alicia Andrews case, I think her case threw all of them up under the bus. Walk with me and I'll explain to y'all more. Her case threw them all up under the bus because in all of their motions and everything that I read, you know what they say? Alicia Andrews was unaware that her boyfriend / baby daddy was going to be driving up to Florida with his friends and that this hit was going to be carried out. So basically, they saying that they did it. She just didn't know. True. I think they'll all stick together. Not for sure. He was naive and forgot about the cameras. You say naive? No, they didn't. They thought that they were being slick, that they were going to catch him up in a different area versus to where they actually stay at in Jacksonville. And they were going up to Tampa. Nobody was going to find them. Blah, blah, blah. Why would anybody expect to come from Jacksonville all the way up to Tampa? Like, they be going to degrees. Like, y'all had almost 3 hours to think about this. And nobody in the car said, this may not be a good idea. Like, what is going on? But I guess when you're on a mission, ain't nothing you can do about it. I mean, they tried once, Sean and Chan, so allegedly. So yeah. I mean, cameras everywhere. They got cameras on the freeway. They got cameras everywhere. They got cameras on the bus. And they should have knew that from when we was looking. They should have been doing a little historical research because that's how the Adelson case came about, because they had them goofies on the bus. Besides the nosy neighbor, he got real nosy. I thought she did not get recused, but they tried. Did I miss it? When you say recused, are you talking about in regards to this case right here, Judge Shamrock? Because she is still on this case. She only was put off Alicia Andrews' case. Yeah, Alicia Andrews judge was recused. Correct. Yeah, that's why she hasn't been sentenced yet. Correct. That's why she hasn't been sentenced yet. 1,200 is the main reason for Foolio's death. Ace and his gang have good ties to them. I can believe it. J. Breezy put out a bounty on them. Rashad is totally medicated. He ain't off that good, is he, Lynn? He off that good, or he off some stuff they didn't put him on? They got to be some stuff they put him on in the hospital. When they sentencing him, at Brian, we haven't went to trial yet. The trial does not start until April. We start picking our jury April the 8th, and we are now in our pretrial motions to determine what comes in, what goes out. And beyond that part of the judge is going to make a decision on Friday in regards to should the cases still stay together. Hey, Most Feared, welcome in. If that illegal search gets tossed, Sean going to get a plea deal. So good. He going to snitch. I don't know if she ruled on that yet. I'll look and see if she ruled on that, but I think she might have ruled on that. I know she kept saying deny. But maybe his is the ones, because I did clip up the videos. Sean's may be the one where she was like she want to reserve and come back. So maybe not. We'll see. Oh, really, Most Feared. Lynn said that shit ain't getting tossed. Her case sure did. Her case said they went to do it, but found out after. Yeah, and that's what I'm saying. Like, her case actually throws them all up under the bus. To me, if you looking at it, it looks like that to me. Like, when I read, I'm like, oh, when I read the motion, we'll read the motions because I pulled them up. So tomorrow we'll read the motion. But when I read it, I'm like, if you take this into this courtroom, into this trial, all the jury got to do is read it, and they're like, okay. Julio was very careful all those years, but before he died, he told everyone where he was. I think he was depressed and wanted to leave. You think so? Aw. Oh, no problem. You know, I'm way late with all of this stuff. And his ops took advantage of that. Absolutely. That's why they call your ops. Did someone say breezy? She's so Thing one and thing two, goofies. Didn't know Uncle put eyes all over them tests. I don't know what they thought. As soon as it felt that movement, the Tesla came on and the cameras on the side of it was like boop boop. It thought it was being stolen, but it wasn't. No plea deals in this case because it's death penalty case, and that's exactly why it's not. When they decided to go for the DP in October of last year, we knew it was on and popping from there. Nobody was getting a plea deal. They have so much evidence. Why would we get them a plea deal? Like, dude, you in 4K everywhere. Why would we give you a deal? She did. It's coming in. She did. Okay. You pretty sure? I'll look and see if I can find some information when it comes in. You said not the full 50K, but some hundreds of dollars. I believe it. All over them Tesla. Her case did them in. I think so too. I think her case did them in. I've been watching your videos for a minute. I know. I like you don't talk while they're talking. You actually pause or wait until the comments are appropriate. Hey, oh, well, thank you. I'll be trying. Oh, I'll be wanting to say some stuff. Now, don't get mad if you catch me on one of these videos where I'll be paused, but I'll be trying not to pause too much because I'll be trying to listen and take notes down so I could be able to talk at some point in time. You say you just spent too much time already. That's cute. Oh man. Well, I definitely truly appreciate all of you guys coming to hang with me while we watch this court hearing. If you want, like I said, we'll be back here tomorrow. I will go over the Alicia Keys. Alicia Keys. I'm sorry. Oh gosh. Checkmate. I will go over the Alicia Andrews motion. I found it fascinating for pieces of parts that I've seen, and I think that y'all will like it also. So, especially if you into all of this stuff. So we'll go over her motion tomorrow. Hopefully, we'll have some information on what they got going on, what happened today. I do know I got an alert because I got an alert when they have hearing schedule. Yeah, I'm way overboard with this. So I know that they got another hearing for Alicia's case in May. So whatever decision or whatever they're doing, no decision has been made because she's still kind of going through the process of going to court. And her next hearing is on May the 10th. So hopefully we'll get some updates and I'll have the documents and we'll go over that all at once. If not, then we'll just do the one. I know. Don't tell Alicia Keys that. I'm gonna get in trouble. No, Alicia Andrews, like, man, no, call her AA. No, call her AA. Yeah, so we'll do that. And for those that are watching the Corey Richards trial, remember we don't start that till 1:30 in the afternoon. And considering that shit show fest that they showed us today, where we went to court and it wasn't no court, I may start that an hour later. I may start that an hour later just in case we have to use some TiVo time because I'm telling you, I don't think Ms. Lewis gonna come with her game face on, and I think that might be a mess. Oh, look at Pretty Brown coming up in here. She said she gonna turn some people green. Thank you so much, Pretty Brown girl. If you received that gifted membership for Pretty Brown girl, I gotta say thank you. Thank you so much. SD, did you see your bong that was made? Now you don't have to do all that puff pass. You didn't even use it, or you can't see it. Yes, yes, yes. Welcome to all the new members. You seen it? Okay. It hasn't refreshed on my at my screen. I can't see it just yet. Thank you, thank you, thank you so much. You just thought, yeah, yeah. I thought it was pretty. She made us a bong, so I can stop doing all this inhaling and smoking and passing it. Maybe y'all can put the bong up and then y'all can just pass it to me. Oh man, that'll make it easier for us while we smoking up in this chat trying to get medicated. Not as medicated as thing one, but you know, whatever. You say, where's my clutch and pearls? I have to ask her, look, I'm so irresponsible. I told her, because you know, we gotta have so many members to do certain stuff. I said, I told her, I said, can you make the bong? I'm gonna take off the gavel. So instead of us being able to hit the gavel, we're gonna hit the bong. Like, that is so irresponsible. I'll tell her that I'll let her know we gotta get some more. I gotta see how many more because they only let me make emojis as I gain membership. So I have to see how many members I need to put something else on there. Because I don't have nothing else to take down. Unless y'all want me to take down the tissue. Maybe I could take down the tissue and replace it and have her do that. But yeah, I'll ask her to do that for us. I definitely will. I'll put out a APB for ask her to do that. But yeah, guys, once again, I want to thank you all. Thank you to the new members. Thank you to the new subs. I'm your girl, Sweet Pea. This is Taking It to Trial, where everybody's taking it to trial because we want to see everybody go to court. We want to see y'all and stop doing. I mean, I guess I could tell you to stop doing crimes, but then what the hell am I gonna watch because I'm a true crime friend? So I'll be wanting to watch this stuff. Anyways, y'all know how we do it. All right, guys.
When Sweet Pea taps in, you know the courtroom lights go bright. Trials running long, but the family's here every night. Mars on patrol, chatter showing out. This little YouTube corner's what community's about. Therapist you know, steady holding down the floor. Behind the scenes magician, keeping peace like never before. A bandit king, a rule keeper too. Every channel dreams of a mind like you. Jason walks in and the ladies lose control. Down to earth king with the warmest soul. Film freaks, kindness, man, it's always on display. Fair and sweet and cheering folks along the way. And Marilia from SA keeps the laughter rolling free. Joking, shining, keeping spirits where they need to be. We're a family in the chat, side by side through every trial. Sweet Pea leads the way with that fire and that smile. We debate, we laugh, we lift each other higher. This courtroom crew is everything we admire. Yeah, no matter what the case so far, we're forever taking to trial. Take it to trial. Pretty brown girl, she'll tell you what's true. Sharp as a gavel, funniest in the room. Dr. Rachel pops in while she's busy running lines. Speaks her mind every time, cuts through like a knife. And Paula brings the energy, jokes flying fast. Helping Sweet Pea backstage, making every stream last. Then Zach's chosen, causing chaos just for fun. The resident cheater, but we love him, everyone. Here comes Maddie, handsome, quick with the line. A comedy sniper with the perfect timing. And Lynn with the updates, always loyal, always tuned. If true crime news drops, he brings it to the room. We're a family in the chat, side by side through every trial. Sweet Pea leads the way with that fire and that smile. We debate, we laugh, we lift each other higher. This courtroom crew is everything we admire. Yeah, no matter what the case so far, we're forever taking to trial. Take it to trial. Shamrock keeps us trending real. the courtroom fog. In Brooklyn in the house, always bringing that spark. Lighting up the chat like a shout in the dark. Bucket loves her grand, speaks truth when it's time. Micrograms with metaphors straight up sublime. Barbara biggest supporter, heart kind of vast. Looking for missing kids, hope to truly last. Only fan from Singapore, flag name but sweet. Still shows up with love every time he takes a seat. And even the part-timers keep this place alive. Curvio, Irish Amy, Capri Law, Hellcat, our tribe. Hearts wide open, stories shared, holding space because we care. From every corner of the world we climb to spend these nights together, one trial at a time. We're a family in the chat, side by side through every trial. Sweet Pea leads the way with that fire and that smile. Mods and shadows, yeah, this love is something rare. A courtroom crew with hearts beyond compare. No matter what the case or file, we're forever taken to trial. To sweet Pea in the mouth and the child we adore. This isn't just a channel, it's a family. And we couldn't ask for more.
All right, guys, if you haven't already, go ahead and join the Discord link with the after party. We'll begin. All right, guys. Peace.